I humbly seek your lordship's liberty, my lord, in mentioning item number 32. Your lordship had heard that matter, that tender matter. And your lordship had asked you to mention it. 12:30 anytime as per lordship's convenience.
Pardon to mention that. One 2018 appeal matter, it could be disposed of at the threshold by a small hearing, my lord. This equal pay for equal, honorable single judge has allowed my application, and it is pending in this court for 2018. It may kindly be taken up.
Who are challenging the order?
Relevance University, my lord.
You are for the?
I am for the lecturer petitioner.
Okay.
And we will permitted to make mention, my lord. The sale certificate has been issued since 2013, but irrespective of that, the physical possession hasn't been handed over to the petitioner. That's the urgency, my lord. So it's coming under the Surface Act.
The petition before my lord, a senior citizen, matter relates to grant of final authorization. Counter agent already filed, my lord. Can be taken up for final step. Another matter related to dismissal from service. We filed in the year 2015 in compliance with order on tribunal, appeal disposal. Then revision petition by revision disposal, challenging both orders. When second way filed, tribunal held that no, there was a delay in approaching tribunal from the date of filing of.
My lord, my CRLA matter challenging the order of conviction, my lord. And IA is there in the bail. IA is there for bail. Pardon to mention, my lord, writ appeal number 103 of 2017. My lord, several memos filed but not listed.
Pardon, my lord. Item number 17. Need some timing on the personal leave. My daughter's admission today. Daughter's admission. 17. I take consent of petition. I am for counsel already. You are for the? I am for the opposite party too. Who is for the petition?
I am for the petition.
So you have received the copy of the counter.
Counter copy they have supplied to me.
Yes.
Some annexes
Some
they have
annexes are
marked
not
it, but that has not been supplied.
That has to be also verified. Okay. And counsel for the opposite party number 2, 6 for an adjournment. And counsel for the petitioner is present and submits that he has received the copy of the counter affidavit filed by the opposite party number 2. But some documents which have been annexed to the counter affidavit have not been supplied to him. Land counsel for the opposite party number 2 submits that he will supply those annexed documents to the land counsel for the petitioner during course of this week. When both of you want to matter.
August 1st week, madam. Any date about?
There's this matter on consent to both the parties. There's this matter in the week commencing from 4th August 2025.
But the interim order they have to buy.
The interim order dated Swanson.
The conditional order. The interim order is a conditional order.
Yes.
That to continue.
Because we continue till next day.
Regulatory commission proceeding.
And it has to come with no other matter. Sorry.
Item 26.
Item 26. Yes.
Item 26. I present next to you, my lord.
26.
26.
You are for the
Petitioner, my lord. State is the opposite.
Counter affidavit has been filed by the state. Any interim order is there? No, right. Or any objection? What is your good name, Land Council? P.N. Mahan. Land Council appealing for the petitioner, 6 for an adjournment. Land Council for the state has no objection. But of this matter, next week, this matter and we will commence from 21st of July 2025 with WPC number 12702 of 2019. Yes.
Item number 6 on behalf of Mr. Kindly permit.
Item number
6.
6. What do you want? What do you want, ma'am?
What do you want?
2 weeks time.
You want adjournment. Any interim order passed? What is your good name?
Adhyasapati.
It in writing. So also appearing on behalf of Mr. Pramod Kumar Mishra, 6 for an adjournment for 2 weeks. This matter and will commencing from 4th August 2025. Yes. Give your name in writing, madam.
Item number 25 on behalf of Mr. Vincent Platform and adjournment.
25.
Mr.
You are appealing for?
For the petition, but I am not having power in this case.
You are not having the?
Power, I have no power.
Then on whose
In
behalf?
behalf of Mr. Prabhat Kumar Das.
No, you
Item number 25.
give your name. Mr. Das has authorized you to
Yes,
make a month. Give your name so that any interim order has been passed. Like, one should appearing on behalf of Mr. Prabhat Kumar Das, 6 for an adjournment. List this matter. We commencing from 4th of August 2025.
Weekly list item number 1.
Item number 1. Oh, item number 1, my lord. I'm asking for on behalf of the petitioner, my lord. My lord, here the petitioner is challenging the impugned award at annexure 1, my lord. That is the order of the presiding officer dated 8/12/2023, my lord. My lord, I seek 2 weeks time in order to, my lord, take some instruction with respect to the present working conditions, my lord.
Working condition of that industry.
No, yes, my lord. In the industry, the seasonal, my lord, it's the opposite party 3 to 34 are the seasonal employees. So, my lord, I need to take instruction whether it is functioning or not with respect to that particular season, that the sugar cutting seasons, my lord.
And that is going on, my lord,
For
because
6 months it works, for 6 months.
Madam,
my
because they have not
So-
obtained stay of the hours. I could not able to get the benefit under section 17B of the IDA.
My lord, just
Now,
1 week
all the
time.
workmen, all the workmen is now.
He wants to know whether they are still surviving or not.
Yes, my lord. Because they are out of job.
It is with respect to regulation of outsourcing seasonal employees, my lord. So that is the whole aspect, whether
And
these
sir.
seasonal employees are required or not in the present, at the present status of the working conditions, my lord.
Because it is required, my lord, it is a, my lord, sugar factory.
Sugar factory, my lord, it's an outsourcing basis. So, my lord, what are the rights if the present season, the industry is not functioning or the present,
You work for 6 months or 9 months?
my lord, 6 to that particular instruction, my lord,
6
7 months,
6 months.
6 months plus 1 month for extra miscellaneous activities.
Generally, they work for 9 months.
Yeah.
Sugar,
One week, my lord, will do.
the 28th तारीख आएगा ना?
28th तारीख, my lord.
Okay, 25.
Again, I have also filed an application for a direction that they should engage me in the
Right.
crossing season.
मूल पूरा बंद अच्छी तांगे वर्तमान भी जाको
ସୁଗାର ଫ୍ୟାକ୍ଟ୍ରି ବନ୍ଦ ଅଛି ମଦ ତିଆରି ହଉଛି
से इंस्ट्रक्शन नहीं होता
With respect to engagement, my lord, how many people
In
are
any case, in these
with respect to
rainy season, it won't be
the
functioning.
engagement of
ଆରମ୍ଭ ହୁଏ ଏପ୍ରିଲ
opposite parties number 3 to 34.
34? ma'am.
କାଜୁରୀ ଭାଇ କେତେ ଜଣ ମରିଗଲେଣି
All are outsourcing employees, not no master servant relationship, my lord.
The land and council for the petitioner seeks for an adjournment for 1 week to obtain instruction relating to the engagement of the opposite party number 3 to 34. Ms. Dipali Mahapatra, land council, appearing for opposite parties number 3 to 34 is present. On consensus of both the parties, face this matter in the week commencing from 28th July 2025 with WPC number 30354 of 2024. Yes.
It is settling matter, your lordship only can interfere, it is a judicial review, like a judicial review. କିଛି ନାହିଁ ଖାଲି council.
My lord, the claim of outsourcing employees now is also a gray area.
Get
Right?
the sir.
Next.
Much okay, sir.
Item 2.
I've already filed the affidavit for a six. In one time. I have already filed the affidavit in regards to instruction to repair the loan. In my para 6 of the affidavit, I have
What is the affidavit? Affidavit not filed like I think. You will find the
11. I have already filed.
Record is Samil in Asu.
Yeah.
The Asiji. Acha, the land council for the petitioner. What is your good name?
Kamodev Mohan.
Huh?
Kamodev Mohan.
Mr. Kamodev Mohanty submits that as per the order dated 25/6/2025, he has already filed an affidavit of the petitioner regarding his readiness and willingness. Affidavit আসবে তারপর সে অর্ডারটা পাস করে ফেলে তো এই বুধবার দিন রাখতে দেওয়া to pay the outstanding dues of the opposite parties number opposite parties bank. Let the affidavit be placed on record court of this matter on 16th of July 2025.
If you are ready and willing, go and pay it to the bank and tell us, we will dispose it up.
Right.
Yes.
Item 3.
May I please? In case, though I have solved copy of original application on Mr. DSC, perhaps I have not filed a copy of original application. That is known.
Whom you have served?
Government of India filed.
Mr. Pari, who is to appear in this case? For Union of India, Mr. Gochai.
My lord, Mr. Panda has been allotted this matter.
Panda mane phone na pura na
J. Panda.
pura na dalo J. Panda.
Sorry, Gyanananda Panda, ma'am.
Yanananda.
Ma'am.
Who is ତାଙ୍କର designation କଣ?
CGC, ma'am.
Have you received the copy of the writ petition?
My lord.
And that
Copy of original application.
original application also.
On 9th May, my lord, I have served. I have copy with me.
Okay. And you have not filed it for the court.
Sir, because there is no noting regarding filing of that in the cause list.
Have you filed it for the court?
Nothing.
ଆମେ କହୁଥିଲୁ ନା ଜବ ଗୁଡାକ ପ୍ଲିଡିଂସ୍ ଗୁଡାକ ଆଣିଲେ ଗୁଡାକ adjudicate କରିବାକୁ ସୁବିଧା ହବ ସେଇଥିପାଇଁ
So I can file today.
ହଁ file can be
I can
found day
file
after tomorrow it can be listed.
Fine.
Okay. it is stated that by the Land Council that Mr. Jnanananda Panda, Land Central Government Council, is supposed to appear for the Union of India. Mr. Bouchard, Land Central Government Council, submits that a copy of the writ petition has been received. Stop. The Land Council for the petitioner submits that during course of the day, you will file the copy of the original application. So also the counter affidavit you have.
I have already filed counter on a regent or along with my.
Acha, you got a file condition already on that original application. And the matter may be taken off day after tomorrow. Place this matter on 16th of July 2025. The original application copy filed be taken on record. Yes.
Yes, ma'am.
Item 4.
And the name of Mr. Swansway reflected in the policy. To file the appearance memo, Mr. Guchayat asked Mr. Panda to file the appearance memo in the meantime.
Ma'am. Obviously.
Yeah.
I think in this case I have already filed amendment petition.
Which one?
Item 4, item 7.
देखा है amendment not received के भी file कर लेना.
11/7.
You have received the copy of the paper copy the Land Council. Your good name is
A.K. Behra.
A.K. Behra Ledial Kigan. So on appearing for Mr. Neochantanga Power submits that as per order dated 25/6/2025, amendment application has already been filed on 11th of July 2025. The Land Council for the state submits that he has not been served with the copy of such application. Let a copy of the amendment application be served on the Land Council for the state during the course of the day. And the matter will be staged for the state on 16th of July 2025 with the amendment application. Yes.
Item 5.
Let us see district magistrate को पाकर section 14 application pending. Listen.
In this case, some page 18, some essay has been filed and OA has been filed. Let the
No, you take instructions. If suppose there is no stay order in that essay, then there is no problem in disposing of it.
State that section 14 is
If
not.
there is no legal impediment, the statute says that you have to dispose of it.
You just submitted that an essay is pending. Maybe essay is pending. but-
Is not a bar.
So therefore you have to.
This writ petition has been filed by Bank of India. A prayer for a direction to the opposite party number 1. Party number 1, Asha. Collector and district magistrate on go for disposal of miscase number 29 of 2024. Filed by the bank under section 14 of the Surface Act, for taking physical possession of the secured assets. The land council for the state took some time to obtain instruction regarding the status of such proceeding. एवढा एई टाइप रो मैटर गुडा 21 तारिख रे रहिछि तने एटा भी रखि दउछु अपन नै आस since similar matters are pending on 21st of July 2025, place this matter on 21st July 2025. Instruction be obtained in the meantime.
Item 7.
Okay. And the petitioners are the legal heirs of the one of the guarantor. And the guarantor has been added as a party as the respondent number 4 million. And your lordship may kindly see the page 14. This is the bank miscase.
What is your prayer in this request?
I have challenged the annex of 4 million, that's the possession notice.
Why don't you go to DRT? Go there.
Here, what has happened?
There is a alternate remedy available.
And it is a possession notice of the.
Yes, what has happened? In the prior to issue of the possession notice, the guarantor is dead and no notice has been issued to him.
Maybe you have a good case, but right.
9/10/24 notice you are challenging now, possession notice, and alternative remedy is also available with you.
And while the back miscase is
We are
against a dead person.
we are giving you liberty, you don't approach. This writ petition has been filed by petitioner so and so. For challenging the notice on the so and so. Annexure 4, possession notice dated for the 9/10/20. Dispose of further liberty grants for them. Yes, next.
Item 8.
I may play the lordship, let him virtual mode. Man. The petitioner before lordship is a group A employee under the BSNL. I may indulge your lordship's attention towards page 47.
Which order you are challenging, Mr.?
I am challenging the order of the Law and Tribunal, Central Administrative Tribunal. Man.
That is annexure is?
Annexure is, my lord, page 66, I have annexed, page annexure 12.
Okay.
Lordship, kindly turn to page 47. Man. I will take 2 minutes. Man.
Just a minute. Let us know that what was your prayer before the Land Tribunal. Have you filed the original application?
No, I have not filed. Compulsory retirement, I will challenge the compulsory retirement which was done at page 47.
No, it's all right. We can keep it day after tomorrow. Why are you not filing the copy of the original application and filed so that it would be better to adjudicate? Okay. You are.
Lordship, I take up 1 week, not day after tomorrow. That 3 days. 2 days, 3 days.
Then let it come on next Monday, 21st.
As your lordship pleases. As your lordship pleases.
Yeah. Mr. Kali Prasan Missile and Senior Advocate files the appearance menu. She's taken on record. Mr. Mishra submits that will file the original application as well as
the counter affidavit.
Counter affidavit filed by the opposite party.
BSNL.
Learning Tribunal during course of this week. And matter may be taken up next week. This matter on 21st July 2025.
As your lordship pleases.
Item 9.
Kindly pass over. Because these are only selected court number 20.
Item 10.
May please, your lordship. The petition is saying for compensation from the bank ballot due to delay issuance of sales certificate ballots. The earlier occasion ballot, the petitioner filed a petition before Honorable Court, and the Honorable Court directed to file proper forum, and thereafter the petitioner went to the ombudsman and filed the petition, and thereafter the ombudsman dismissed the case, and thereafter this writ petition has been filed.
How have you quantified this 5,000 compensation?
Well, that is the RBI guidelines. Well, let's kindly see Annexure 7, page 27. Well. I've annexed the guidelines of the RBI. I'm reading notes. Column 6, compensation for delay in release of movable, immovable property documents. In case of delay in releasing of original movable, immovable property documents or failing to file charge satisfaction from the relevant register beyond 30 days after full repayment settlement of loan, the RE shall communicate to the borrower reason for such delay. In case where the delay is attributable to the RE,
that's the problem. Attributability factor is a question of fact to be decided by some other court, not the writ court.
Some other court means, my lord, the ombudsman.
We don't know which court. But writ court can't get into the disputed question of facts.
The thing is that suppose they now appear and file the counter affidavit and bring some material that you are responsible. So question is that how can we adjudicate this matter and ask the opposite party to pay compensating the amount of rupees 5,000? That is what my esteemed brother is asking you.
Go to ombudsman.
The RBI guideline is there.
Yes,
so, can you not raise this issue before the ombudsman?
Yes, my lord. The ombudsman order, my lords, I have annexed, my lord. Kindly page 14, my lord. Page order 15, page 14. Next page, my lord. The complaints are inadmissible under the scheme, hence the complaint stand closed. Page 14, my lord.
14 to 15.
Page 15, my lord. Ombudsman order.
ପଢନ୍ତୁ ଆପଣ କୋଉଠି ଲେଖିଛ ଲେଖା ହେଇଛି କୋଉଠି ପଢନ୍ତୁ
15 page
15 ପେଜ ର କୋଉ ପାରାଗ୍ରାଫ ସେଟା
ଲାଷ୍ଟ ମାନେ ପୁରା ଲାଷ୍ଟ ଫାଷ୍ଟ ଟୁ ଲାଷ୍ଟ ପାରାଗ୍ରାଫ
Para 6.
no ସଭା ଉପରେ ଏଟା 3 ପାରା
ଆସିଆ କହୁନାହାନ୍ତି
ପଢୁଛି
please read it out.
Upon security of the complaint, it is observed that the complaint is seeking for compensation for delay in release of property documents which were e-auctioned by SBI under Surface Act in 2023-24 and taken possession by the complaint in March 24. Such complaints are inadmissible under the scheme, hence complaints stand closed.
Look, this petition has been filed by the petitioner Rajesh Kumar Mishra for a direction to the opposite party hyphen bank to pay compensation amount of rupees 5,000 for each days as per circular of the RBI dated 13/9/2023. Since there was a delay 8 months in giving possession of the property to the petitioner by the bank, and the delay is attributable to the bank. The Land and Counsel for the petitioner submits that though he has approached the ombudsman with such prayer, but it has been held that the such complaints are inadmissible under the scheme. and accordingly the complaint stood closed. And it was further held that such complaints are non-maintainable under the clause 16(1)(a), 10(1)(f) of Reserve Bank Integrated Ombudsman Scheme 2021, which specifies that no complaint for deficiency in service are liable under the scheme in the matter involving a service not within the regulatory purview of the Reserve Bank. The Land Council for the petitioner pointed out, who page ka put dile?
This is 27 RBI guidelines. Annex of the
Place the RBI guidelines dated 13/9/2023, wherein in clause number 6, which relates to compensation for delay in release of movable or immovable property documents, comma, it is stated as follows. Quote entire paragraph number 6, that clause number 6, which is at page number 28. Stop. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. So, any panel counsel is there for Reserve Bank of India. On the State Bank.
Member State Bank of India.
No, it's all right, but there may be a number of counsel and they may engage any counsel. So we cannot say that let it be copy be handed over to you. So you file your requisites. Requisites for issuance of notice on opposite parties be filed during course of this week. Okay. Matter will be listed 4 weeks after. Yes. Okay.
Item 11.
4 weeks after. 4 weeks of delay will agree.
The notice to GO.
What will happen to the delay spend?
It's not just a new thing. Yes, I think that. You see, next week, with the time, take the note, resume some jobs, section 26. Ultimately, the continuous call of action. If we hold that is ultimately liable. 27 like was in normal course, the one other day.
Item 11 and 12, as per the instruction manual and Advocate General, he is in leaks in other matters, right? Perhaps some other day.
Some other day.
Some.
Continuation of delay.
I am appearing again on 115.
How much delay is there?
18 days.
Let the delay be condoned. Admission.
What do you say? They have no objection for condonation of delays.
That what instruction I have received from Learning Advocate, that's
what do you say, ma'am?
I have been engaged to assist the Advocate General by the order of the full court.
No, it's all right. But
it actually there is hardly a delay of 35 minutes, though the registry has shown. So the chutti period ta padi hai,
but they have no objection, so what is there? If delay can be condoned, it can be taken up on other day. What is there?
Yes, absolutely.
So, any to that effect, any problem, any objection? No. But you have filed the delay condonation, they have no objection. So,
See, synopsis. The synopsis.
Synopsis and the entire petition, the name of honorable judges are written.
That has been vetted, your lordships. Everything has been vetted and.
As your petition, but name of in the entire judgment, we avoided.
We avoided that. Say.
Because, Your Lordship, all the records have been placed, everything, because they are part of the inquiry report, everything.
Can't get it in the pleadings.
It has been vetted, Your Lordship, so
That's right, it is your thing, but expression like the presiding judge, puisne judge, or senior judge, junior judge, there are many expressions are available to you to use instead of writing the names of honorable judges. High Court is High Court. Why judge's name in the pleading or for that matter anywhere? High Court is High Court. Whether X judge passes the order, Y judge passes the order.
It's embarrassing. Right, it is not proper actually. That is why we did not name any of the honorable judge so in the entire judgment.
Think over if you have time.
We are not.
You have petition. We can't.
We are just continuing.
It is a question of taste,
Your Lordship, that is the contrary, will give the copies. Give the copies.
If you can
As because it has been vetted, so I cannot
whatever that's
your anything to Your Lordship.
Outlook is yours. It is your petition. Dominus litis.
We'll come up with next time Lordship, when the matter comes, we'll apprise Your Lordships on that aspect.
Generally, because in the judgment we have very carefully avoided the writing the name. Obviously, one shouldn't. In the pleading, it should be equally avoided. That's the.
Have you taken the names of the honorable judges in the?
Your Lordships, all the order sheets are also there. So therefore, Your Lordships, in the document itself, the name of the judges are there.
No, that's
the whole
documents is something.
They are part. They are made public record now. So that is the whole thing. But I'll get back, Your Lordships, on this point. We'll serve the copies. Get back on this point. And anyway, these copies are going to my.
It is up to you. We are not expressing.
Copies are going to learned seniors. So I think if changes are made, we'll cooperate.
Think over the matter.
Yes, Your Lordships.
You can avoid. Why not?
I'll get back. I cannot so motor say that.
No. We don't say. We just think of Lecon. Year number 247 of 2025. The stamp reporter has pointed out that there is delay of 18 days in filing the review petition. Who has entered appearance for the opposite party?
1559, I'm appearing with Mr. Ratha.
The Learning Council, Mr. Sahoo Hon'Ble, Learning Council, has filed the appearance memo. And senior advocate has filed the appearance memo for the opposite party number 1, which is taken on record. And he submits that he has no objection if the delay is condoned. In view of such submission, the delay in filing the review petition is condoned and I is disposed of. Let a copy of the review petition be handed over to the Learning Council senior advocate by
a week.
Within a week.
Similar order in the other same day.
Except
2 judgments were there. One was CCR matter, one was the
Delay
period. Ethere ki appear question.
Mr. Buddhadev Ratha, we have
Have you filed your appearance?
Yes, Your Lordship. We have already appeared.
18 days.
Nahi to appearance memo. Appearance memo or lekun. Review petition number 160 of Swanso, IN number Swanso. There is an application for condonation of delay, same like 18 days delay. It is stated at the bar that Mr. Buddhadev Ratha and senior advocate has already entered appearance for the opposite party number 1 by filing the appearance memo. The appearance memo be placed on record and it is stated by the associates of Mr. Raut that he has no objection for condonation of delay in filing the revision petition. Accordingly, the delay in filing the review petition is condoned. IA is disposed of. Same order copy is up within Swanso. So Till when both the matters can come, the date you can say can be mentioned there.
2 weeks after, we'll serve the
Give,
copy.
give,
2 weeks after.
give us any date, we just want to, please.
2 weeks will be far away.
Because ये एडवोकेट जनरल को भी पचारन तो कारण से आगू करिवे जे मैटर
हाँ मु तो कहले हबन से
नहीं नहीं मु सेट में पहुंची अपन पचार नेक्स्ट वीक you give it in the
some within other.
please mention it, give date, and we can record it. Afterwards also you can give it. Of course, intimating this. You date they will mention.
In the second matter also.
Second matter, same thing.
Names of honorable judge.
I only pray my lord that it should not be unusually delayed. 2 weeks.
No, he is telling you about 2 weeks. So
10 days, 7 days.
Twenty-nine.
Next week.
29th ରଖିବେ କି
ହୋମିଓପାଥିକ
କହୁଛି ଆପଣ ଯେତେବେଳେ ଆଜି ଗୋଟେ ଦେଇଦେଲେ ସେ ଲେଖିଦେବେ ଠିକ yes next okay
Item 13.
Amendment, though the said annexure is annexed as 26, but inadvertently it could not be written in prayer, and that is also one of the impugned order. Because the impugned order annexure 1, thereafter the petitioners filed a review RA application before the court, and the court has that has been dismissed at annexure 26, my lord.
Just
So therefore on the last occasion.
let us see that I now come to your schedule of amendment.
Yes, ma'am.
Oh, this much of you want to
My lord.
notice has not been issued earlier.
No, my lord. While I am submitting these facts before this honorable court, this honorable found that since after the judgment you have challenged and one RA is filed, that is annexure 26.
Year numbers 1, so this is an application for amendment considering the nature of amendment and shortfall and amendments taken in the interim application. We are inclined to accept the prayer made in the interim application. Accordingly, prayer is allowed. The IA is disposed of and counsel for the Union of India shall file the consolidated writ petition during course of this week, court of this matter. So, yes.
21st. Next week.
Upon file for the
Item 14.
That matter of the Reserve Bank rate of interest.
In this matter, my lord directed to file affidavit, a responsible officer. I place not adjournment because the chief manager, branch manager,
just a minute.
has been transferred.
Just a minute. Please, let us go through the order. The last order is dated 36/25. Oh, that MSME matter.
My lord.
2006 onwards.
It was granted from 2009, but according to him, it should have been granted from 2006. So that period from 2006 to 2009. So after perusal of the counter evidence, we find no specific reason has been assigned denying the relief sought for so let a specific affidavit. AI को affidavit.
Chief manager, branch manager has been transferred, and the deputy manager has met an accident and is brain hemorrhage hospital.
1 week.
Mr. Mahathir concern near to Quebec Oil.
Actually, 1 minute, your lordship may kindly bear with me. You have to kindly look at section 7 of the micro, small and medium.
No, Mr. Mahathir, we have already passed it.
There cannot be any dispute that I am entitled. Because I come in the first schedule and
But we agree with you, therefore we want an affidavit. We agree.
An affidavit is to be filed and he expressing some difficulty. So tell us one date so that he will file the affidavit and it's a simple matter.
Tell that I don't know when the another branch manager will come.
No, we just gave an opportunity. If we
Maximum 1 week.
What do you say?
Maximum 1 week.
See, somebody has met with an accident, it's all right. But simultaneously, this case is lingering from 2013 and somebody must also be in charge of the bank.
Bank must be functioning.
Now that for him, the bank is closed. So he has to see the documents and file it. You must have said, send this order copy to him also.
But I have also sent and I have also prepared a short affidavit. I sent, as the order is responsive officer, so manager, deputy manager, both are absent. The person who is in charge, that's the law. That's the law officer requested me. It's only 1 week, your lordship.
Okay, 1 week it's all right. The land council for the appearing for the Union Bank. 26, 1 week for the time to file the affidavit as per the order dated 36/2025. Is this matter?
21st.
25 तारीख के लिए चढ़ी वो and 25th of July 2025.
शुक्रवार टा रखन
पहले पर आपनो 25 तारीख
25 तारीख
आपनो 25 नहीं मुगल 25 तारीख ना he has some difficulties and
that is right. 21st would be sufficient.
let him be. Then if you have got some difficulty on 25th, then let it come on 28th. If somebody has
25th ଆଉ ଆଜ୍ଞା ସେ ଆଡକୁ ନାହିଁ ଯେ ଆଡକୁ
25th ठीक है ना all right.
Friday ଟା ଅଛି ତ କେତେବେଳେ ଫଙ୍କସନ କରିବ ନ କରିବ କଣ ଗୋଟେ Friday last Friday ହଉଛି ଏଇଟା ଫେର କରିବ ମାନେ ସବୁ
Friday say after launch से जो reference travel से तो but this will come in the first hour, so there is no 25. Sorry. Yes.
Item 15.
My lord, I am appearing to the petitioner. My lord, it's a matter filed in 2015 challenging the ECIR. Actually, what is reported by an affidavit by the PD department, ECIR is simply the internal communication number. And in the meanwhile, my lord, the schedule offense, which was in fact based on which this particular prosecution is initiated, has been quashed by the Honorable Court in 2021, and subsequent to that, the Honorable Apex Court also quashed the in 32 application, quashed the particular ED proceeding also, which was pending before the district judge. So far, present petitioner is concerned. Adjudication. Now, my lord, I'll just try my attention, my lord's attention to affidavit filed by the ED.
Filed before special court was
Quashed. Now, lordship, to kind glance to 9th February 23, the affidavit filed by the ED.
It appears it is a 482 petition in disguise.
No, I'm just playing, my lord. Only lordship to observe the para 5, wherein they say, para 5 of that affidavit, wherein they say the petitioner is not an accused. So that part particular, it can be disposed of. They admit that all the proceedings has been quashed. Both the vigilance case has been quashed by this Honorable High Court in 482. Thereafter, based on that, the matter was moved by the accused, Indrani Patnaik and Diptirendra Patnaik, before the Honorable Apex Court. Apex Court, in fact, allowed that. And the prosecution...
Where are those orders?
My lord, that is filed along with my IAC.
So now then why don't you file a 482 petition and it invitation there?
No, it can be, I just want to accept the affidavit filed by the department. ED. Para file.
This REIT application become infrastructure. Also kindly see the prayer at
Prayer, what is the
51.
prayer?
Right. That's what.
Prayer at page 61. This REIT application was filed without challenging the virus of PMLA. And now your lordship knows that has been upheld by the apex court.
Yes.
The second prayer was issue writ of certiorari and or any other writ, order or direction quashing the entire proceeding, prosecution and adjudication under ECIR BSZO ECIR 06.
That is the reason I am saying you.
This
482 in disguise.
This ECIR doesn't belong to him, petitioner. This ECIR belong to other persons.
So that
where your lordship has get the judgment. So this ECIR number itself is wrong.
I have kept a judgment.
Yes, my lord. ECIR number 7 was registered, my lord. They have filed an application for amendment. Your lordship kindly see IA.
No, first, just 1 minute. Mr. Abdul,
yes.
The first prayer is concerned, you have stated that the Honorable Supreme Court has
upheld the virus of
the decision.
Vijay Madanlal Chaudhary, my lord.
Judgment.
We are no more on that point.
This is, my lord, reported in 2022 SCC online. 2022 SCC online SC 929. Vijay Madanlal Chaudhary and others versus Union of India and others.
That is thicker judgment.
Vijay Madanlal?
Vijay Madanlal Chaudhary. So lots of candidates.
That's the 2022 judgment. July. That is already filed. That is already filed by us.
Wait. So, so far as the first prayer is concerned, it has already been declared as such. So there is nothing to be decided here.
Yes.
So far as number 2 is concerned.
Yes, Lord.
You mean to say that though the prayer has been made by the petitioner to quash the prosecution in this particular ESIR,
yes,
that doesn't belong to the petitioner.
Yes.
What do you say?
Only
the second one is concerned.
The only point, my lord.
Only ECIR
number is 7 or 6.
Correction of amendment petition to file.
Fine.
My lord,
1040 2017.
The ECR number is only to
this case number 1040 of 2017.
Inadvertently?
7
07. 07 to does it matter? Kind glance to page
regularize ए सब गुड़ाक आपनकर जदि आमे अमेंडमेंट अलाउ करिवो देन यू आर टू फाइल ए consolidated one that writ petition.
That ECR also you have to file everything. Then only we can.
Otherwise you can.
I'll file it together.
IA number first like this writ petition has been filed by the petitioner. What is two petitions filed? What
it can be
the petitioners with following prayers. I quote for level A and B. So far as the prayer number A is concerned, the Mr. Gopal Agrawal, senior advocate, appearing for enforcement director, opposite party number 2, submits that the Honorable Supreme Court, in the case of Vijay Madanlal Chaudhary and others versus Union of India and others, reported in 2022 SCC online SC 929, has already answered this issue and offered paragraph of.
In fact, all sections of the PML Act has been upheld by the
offered the provisions of the PML Act, PML Bracket Amendment Act 2013. Stop. Mr. Mahapatil and senior advocate appearing for the petitioner doesn't dispute this thing. So far as the prayer number B is concerned, Mr. Agrawal pointed out that number is the ESI number which has been mentioned therein doesn't relate to the petitioners. At this stage, Mr. Mahapatil and counsel and senior advocate submits that an interim application with IN number
1040
of 2017 has been filed for correction of the case number in certain paragraphs, so also in the prayer portion, and the same may be considered. Stop. Mr. Agrawal has no objection to the prayer made in the miss case for amendment of the case numbers. Accordingly, the prayer made in miss case number 1040 of 2017 is allowed. Mr. Mahapatil, 6 time for 1 week to file a consolidated writ petition incorporating the correct ECIR number. Put up this matter. Any date?
End of is 29?
29.
30th matter.
30th matter on the 30th of July 2025. The copy of the consolidated petition be handed over to Mr. Agrawal. Yes.
But for the prayer number 1, the matter was listed before division bench. If prayer number 1 goes, it will go to somewhere.
During the pendency of the writ application, the events that has taken place, that has completely.
That's the reason.
Thing like accepting the affidavit by the ED. That one.
Okay, next.
Item 16.
In item 16, I pray one time, my lord, on behalf of Mr. Pariposan, Mr. Senior Advocate, my lord.
I am appearing on behalf of Mr. Das for the respondents. My lord, before that, your lordship, I beseech your lordship to look at your lordship's order number 4 and 5. My lord, here is a case, my lord, may kindly see your lordship's order number 4. The second paragraph. The first paragraph. Second paragraph.
No, one IA is pending for condonation of delay.
My lord, that's their IA.
And in fact, the stamp reporter has pointed out that there is delay of 88 days. Any order has been passed to that effect?
No, my lord.
For condoning the delay.
No, my lord, on 7/2/2020, my lord.
7/2/2020.
20, my lord. Interim order was, my lord, passed, saying that Honorable.
Whatever it may be, we are asking you for the condonation, the delay has to be condoned. So, issue notice to this one. So that is that 433 the notice is in 434 electric. 434 tag on stay matter.
434 stay matter.
Overlook there was a delay. So it is to be regularized actually. So any objection from your side? Delay. IN number 433. No, this thing should be IN number 433 of 2019. This is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 88 days in filing this writ appeal. The Learned Counsel appearing for the opposite party or respondent person. Respondent had no objection in the matter of condonation of delay. Accordingly, the delay in filing the writ appeal is condoned and IA is disposed of.
Yeah.
Now you come to the main thing.
My lord, may I only say, my lord, my submission may not be recorded, my lord, because already so much has been passed.
Has no serious objection.
Because I may have misunderstood.
Has no serious objections. So in view of the fact that notice has already been issued and stay had been granted. And the
Here, madam, the only thing is, madam, what has happened in the
interim order of stay has been granted. Yes. Yes.
In a way, madam, already by interim order, madam, may kindly have a glance at interim order number 4 dated 2/3/2023. There, my lord, while granting an adjournment, my lord, may kindly see para number 2. In the interest of justice, list on 6th April 2023. In the meanwhile, the applicant will hear the respondent in terms of the impugned order and calculate the dues, but not disclose it till the next day. My lord, may kindly then look at the next order. Order number 5. Again, an adjournment was sought for. There also, my lord, this honorable court, by order dated 6/4/2023, my lord, may kindly see para 3, 4, 5 may be relevant. Para number 3, they say, with the respondent, my lord, has it been? With the respondent not having worked during the period when he faced the criminal proceeding, that is from 1997 to 2009, he cannot, on the principle of no work, no pay, be expected to be paid arrears of salary. Nevertheless, the said period would have to be counted for the purpose of fixation of his pension. Secondly, as regards the plea of the respondent that during the period when he was in service, he had earned 3 financial increment, that is an issue which will be examined by the bank and the benefits worked out accordingly. Mr. K.P. Mishra, learned senior advocate appearing for the bank, states that within a period of 4 weeks from today, the bank will rework the financial benefits due to the respondent, both as regards the financial increments earned by the respondent, as well as the consequential fixation of pension by including the period during which the respondent was out of service. The details should be communicated to the respondent not less than 1st June 2023. My lord, nothing has happened in the meantime. And my lord, I'm already 67 years old. I'm already superannuated, man. I have health issues with my...
That decision was communicated. The next step, my lord, I will also file affidavit.
No, you want the personal appearance. So.
My lord, that was communicated to the respondent on 16 August 2023, my lord.
If he is not obeying you, then let him appear on person.
That was my lord communicated. Already that
communication is one thing, but if he is not acting upon the order of the clear court order is there.
Yes, my lord.
Then he has to answer it. That why he has not.
Personal hearing was given, my lord, and that decision was communicated to the respondent, my lord.
In the meantime, in view of this order.
Yes, my lord. 16 August 2023, my lord. 16 August 2023, my lord, that was communicated. My lord, a detailed affidavit will be filed, my lord.
Have you received?
Already that is communicated.
No such instruction. Copy may be given, my lord.
My personal copy. I'll give a copy.
Okay, let on. The London Council appearing for the bank submits that in pursuance of the order dated 6/4/2023, what has been held on the basis of these orders?
Can you give a copy of that? Just give it.
This is my personal.
No, we will give it back.
Give it back.
Yes.
Wherein the bank was asked to rework the financial benefits due to the respondent, both as regards to the financial increment earned by the respondent as well as the consequential fixation of pension by including the period during which the respondent was out of service, the decision has already been taken and the same has been communicated to the respondent by letter dated 16/8/2023, and you will file an affidavit by one of the responsible officer of the bank by next week, serving a copy on the land council for the respondent. Stop. The land council for the respondents also submits that in the meantime, he will obtain instruction from the respondent as to whether any such communication of the bank dated 16/8/2023 has been received by him or not. So let it come on 28th then. You just file an affidavit.
On 30th, Sambalpur, Malad to Sambalpur.
30 तारीख तो all right. List this matter on 30th of July 2025. It is fair area.
Lots. Thank you. Keep your place.
Number 60.
Keep your place.
Malad interim order.
Interim order अच्छी.
Lot fill.
Interim order dated 7/2/2020. So continue till the next date. Yes.
Keep your
Obliged.
Item 18.
In this case, I challenge the order of the State Administrative Tribunal, Central Administrative Tribunal.
Who is appearing for the Mr. Mahanti and Mr. Tripathi? Union of India. Mr. Pari.
Pleading is complete. It's ready for hearing.
When?
Union of India. Yes.
That's it.
Mr. Pari, no one is there here. Item number 18. It's for final disposal. And pleadings are complete as it appears.
Yes, madam.
Mr. Aurobindo Mahanti and Devasis Tripathi's names are there in the cause list, but no one is appearing.
Which matter?
18. Item 18. 1-8.
18. They both are not in our penal Lakshmi.
Ame kon koribu?
I will appear, my lord. Lakshmi give some time. 7 days time.
Mr. Devasis Tripathi is there, na?
He is also joined in this state.
Okay.
Both of them joined in this state.
Argument put. Mr. Pari, Land and Deputy Solicitor General submits that though Mr. Aurobindo Mahanti and Mr. Devasis Tripathi have engaged as the central government counsel to argue this matter on behalf of the Union of India, but they are now in state panel and someone else is to be engaged for arguing, and the matter may be taken up a week after. It is this matter in the week commencing from 28th of July 2025. In the meantime, the Land Deputy Solicitor General shall do the needful in engaging one of the counsel for the Union of India. Mr. Pari.
Yes, along with me, Mr. Santosh will appear. Let's repeating name. Santosh Samantara.
Mr. Santosh Samantara. 28/7/2025, Rasul. And the Land Counsel for the petitioner is present. All right. Yes, next.
Item 19.
I'm appealing on behalf of S.Mishra. Kindly praying for kindly 1 week time.
Pleadings are complete.
Hmm?
Pleadings are complete in this case.
Hmm.
And be posted for hearing.
You are mentioning on behalf of Senior Advocate Mr. Mishra. You are seeking for an adjournment. Which date you tell us? Which date you want?
1 week after. 21.
What is your good name?
You can
Give it in writing. wants to appearing for the senior advocate Kali Prasanna Mishra, 6 for an adjournment. It appears that the pleadings are complete. 1 week time for them. Put of this matter in the week commencing from 28/7/2025. The Ms. Suvalakshmi Devi, Land Council for the state is present for this.
Item 20.
In item number 25, order dated 5/2025. So Lordship are directed to take instruction whether any other policy can be applied to the petition. That instruction is still awaited. Can you pray for next week?
I'm appearing for the corporation ownership, OP 2 to 5. Here the claim of the petition was issued on the plea that the RA policy is not applicable to the present petition as because its father voluntarily take voluntary retirement with the undertaking that he will not claim any further.
The last time it was the submission of the Land Council for the appellant.
Yes.
That a policy has been formulated by the state government or to give appointment under this rehabilitation assistance scheme. So he was to, she was to take instruction. And she wants it to next week.
Yes, ma'am.
Ms. Suvalakshmi Devi, Land Standing Councils, submits that the instruction as per order dated 5/5/2025 is awaited, and the matter may be taken up next week. Please this matter in the week commencing from 21st July 2025. Here.
My appearance.
The appearance would have the one. So they don't sleep curriculum.
Item 21.
On behalf of Mr. One pastor.
Wait, can I pray for tomorrow?
You want it tomorrow, it cannot be listed. Day after. As prayed for by the Ms. Suvalakshmi Devi and Additional Standing Council. This matter on 16th of July 2025.
Item 22.
Item 22, one week time we given to file the reply to the regional. I have received the draft reply and already sent to the Department for
What you have received?
The draft reply to the regional.
Who is appearing for the petitioner? Mr. Ojha. S.K. Ojha is not there. All right, none appears for the petitioner. Land Council appearing for the Union of India submits that he has received instruction for filing a reply to the rejoinder affidavit filed by the Land Council for the petitioner. And the matter will be taken up a week after. Place this matter in the week commencing council 28 July 2025. Reply, if any, to the rejoinder affidavit will be filed in the meantime, serving copy on the Land Council for the petitioner. Yes.
And in this case, perhaps interim order of the petition.
Interim order. No. Interim order तो किसी नहीं कूद नहीं था ठीक है ନାହିଁ କିଛି ନାହିଁ ମିଷ୍ଟର ରାୟଗଡ there is no such interim order କେବେ ହେଇଥିଲା
କୋଡିଏରେ ବୋଧେ ନା ମୋ ପାଖରେ ନାହିଁ। କୋଡିଏରେ ଆମେ we have filed also requisition of interim order।
ମୁଁ ତ ନାହିଁ ଆଉ ଶିରୋ ନାସ୍ତି ଶିରୋ ପିଡା କର ଆପଣ interim order ନାହିଁ ଆପଣ ଫାଇଲ କରିସାରିଲେଣି ଭ୍ୟାକେସନ କୋଉ ଦିନ କହୁନାହାନ୍ତି interim order ଦେଇଦବା interim order ତାହେଲେ କନସିଡର ଦେଇଦବା ତାପରେ ସେଟା କନସିଡର କରିବ ଲେଖନ୍ତୁ so yes
Item 23.
May I please? May I please? Lordship, just a glance to order dated 18/6/2025. It is a covered matter. For that reason, your lordship directed that to take instruction whether this case is well covered by the decision of this particular
Union of India and another Moses Naveen
Yes,
Kumar.
Naveen Kumar
They
Senapati.
have cited a decision
Please to
WP
study
now
this
5178.
judgment and tell us that Union of India.
Union of India.
Mr. Pari,
We have received the copy of the
he stated
order,
that
but
a judgment has already been pronounced earlier by this court
Yes, ma'am.
on 17/4/25, and this case is covered by that decision. Have you studied that?
18/6/2025, my lord have passed an order.
Yes.
We sought for instruction, that's been another 7 days time, we have not received. Last time may be given, other instruction.
All right, Mr. P.K. Pari, Current Deputy Solicitor General, submits that he has got the copy of the order dated 17/4/2025, passed in WPC number so and so. The order dated 18/6/25.
Mr. Party, what instruction you'll get, whether the case is covered by a judgment or not, you have to tell or you will receive instruction?
Only have to take judgment is one part, another part is just similar nature of any case or there
You have only asked whether
Supreme Court or
this case
not.
is covered by the judgment or not. You have to read and tell, not you seek instruction.
We have to study the factual aspect also of that case and this case, and simultaneously the ratio let down, and then so we are just keeping it another date level. Covered by the aforesaid order, and he seeks for an adjournment to verify the same, put up this matter. It is 18 तारीख रे रखियो माने कोन more you want more time
10 days is okay.
Yes, division, everything is same.
25th July.
Yes, ma'am.
25th July 2020. Yes, next.
My lord, I may be pardoned. Item number 21, your lordships have kept it to 16th. Can it be on 17th?
Mr. Ratha, the Tuesday and Thursday, those are the dates in which another bench is functioning.
Then my lord, on 18th?
18th it can be. What do you say?
Yes, sir.
It is your short or 3rd तारीख. Yes, next. Like Mr. John Kumar Rothland, senior advocate, is present on behalf of the respondent. Yes.
Item 24.
I am appearing in person in this case. All the pleadings are complete and today is date for final date.
You are ready?
Yes, I am.
Yes, Mr.
And it is dealt with Mr. Pradhan, he also on the central government panel. I didn't have a record, or let me keep after 1 week.
Tell us the date, because the
after 10 days, any date convened to the, because he appear in person.
The London Council was engaged by the Union of India to address the matter. He is now no more in the panel. So you tell us another date, another council is to be engaged. So as per your convenience,
Next Monday.
he wants it on 21st. Are you?
Can it be 28th?
28?
Or 29? 29 is better.
28. Let us keep it on 28.
Yes,
Mr. S.Mishra and the petitioner in person is present. Mr. Deputy Solicitor General submits that the matter was earlier entrusted to Mr. Chandrakant Pradhan, who is no more in the panel, and somebody else is to be engaged to argue the matter on behalf of the Union of India, and the matter may be taken off in the week commencing on 28th of July 2025. The petitioner has no objection to the same. List this matter on 28th July 2024, right?
I asked Mr. Samantara to appear in this case. If they are,
All right, just file the appearance memo and
yes, yes.
if any of the counsel from the Union of India enters appearance in the meantime, his name be reflected in the cause list in place of Mr. Chandrakant. Right? Yes.
Item 27.
Mr. Guchait, it is your matter.
Yes, yes, yes. Yes. My lord, in this case, my lord, the petitioners have challenged the legality and validity of order dated
10,000 rupees what you have filed, where is that order passed to deposit 10,000 rupees in which?
My lord.
Every order is allowed.
It was paid. It was paid also. It was paid.
In pursuance of the order dated 18/11/2024, deposit of rupees 10,000 has been made by the Union of India in the Orissa High Court Advocates Welfare Fund, and receipt to that effect has been filed, which is taken on record. Stop. You are appearing for the opposite party. You have not filed any counter affidavit.
Not necessary, madam.
Not necessary.
I have filed a.
Just a minute. We are recording your submission. The land counsel for the opposite party, you are the sole opposite party, submits that he doesn't want to file any counter affidavit. Yes, you can argue the matter.
My lord, in this case, my lord, we have challenged the order dated 21/6/21 and 19/10/23 passed by the Learned Tribunal in OA number 816 of 2019 and review application number 9 of 2021, my lord.
One is Annexure 7, the other is Annexure 9.
Man. Annexure 7 and 9, man.
So Annexure 7 is the order passed in that way.
Man.
And 9 is the order passed in that review petition.
Review, man.
Okay.
Man.
So what was the prayer of this opposite party before the Land and Central Administrative Tribunal?
My lord,
to draw the salary against the post of Office Superintendent Level 7 from 16/4/2014 instead of the order passed by the tribunal dated 8/12/2017. Item number 27.
my lord, the opposite parties.
Please.
My lord, the opposite party.
Just a minute. You come to the operative part of that order passed by the Land Tribunal. I think it is paragraph number 12. The region has been assigned and thereafter the OA has been allowed.
Married, my lord?
Yes.
If the stand taken by the respondent is accepted, then virtually it will amount to imposition of punishment by the respondent's authority on the application for the purpose of reducing the pay of the applicant from 15/4/2017 to 8/12/2017, although the same order of punishment was quashed. It appears that the respondent department was inclined and took step for implementation of the order passed by this tribunal in Annex A/3 in letter and not in spirit. It was not necessary in circumstances of this case for the respondent department to insist that in the absence of any consequential relief granted to the applicant, he was not entitled to the pay which was getting in capacity as Chief Office Superintendent with effect from 15th April 2014. The necessity of passing consequential benefit arises maybe in case of giving retrospective promotion, notional promotion, or when the applicant is out of job and is directed to be reinstated by any tribunal or judicial forum. But in this case, there were no necessity of passing any such order for giving consequential benefit. And in the absence of any such consequential relief granted in favor of the applicant, still then the respondent department cannot take the stand that the applicant is not entitled to his salary as Chief Office Superintendent with effect from 15th April 2014. Of course, if the applicant has not worked as Chief Office Superintendent with effect from 15/4/2014 to 8/12/2017, then he may not be entitled for any particular allowances like traveling allowances, etc., to which a person is normally entitled if he works in that capacity on day-to-day basis for that period. But claiming pay of Chief Office Superintendent with effect from 15/4/2014 till 8/12/2017 does not at all come under scope and ambit of consequential benefit, and the right and claim of the applicant in the present origin application is clearly covered by the earlier order passed by this tribunal via Annexure A/3, and therefore the respondents were duty bound and legally bound to grant pay in favor of the applicant, which he was entitled to in his capacity as Chief Office Superintendent with effect from 15/4/2014. Madam.
So where is that way, the earlier order?
My lord, that is
Annexure 4.
Annexure 4.
Annexure 5 is a CP. My lord, propose OA along with the count.
Miscellaneous applications.
My lord.
You are right, he is right. Annexure.
Page 170.
170. Sorry, ma'am.
That is the operative part of the order.
Paragraph
7 to 170.
Ma'am.
Taking
cumulative view of the entire scenario, it is
abundantly clear
that holding the delinquent employees guilty of consuming liquor has not been proved legally, as the inquiry officer reached to his conclusion based on the preliminary inquiry report, which cannot be taken into record. Hence, order O is allowed. Inquiry report dated 25/3/2014, Annexure A/10, disciplinary order dated 15/4/2014, Annexure A/12, and the appellate authority order dated 11/7/2014, Annexure A/14 are hereby quashed. No costs.
So here, of course, it has not been mentioned that all the consequential benefit is to be extended in favor of the applicant. That is not there. So that is how you have deprived him, and he has come to the tribunal, and the tribunal has passed the order under Annexure 7.
My lord, in the OA 648 of 2014, the applicant, the opposite party the sole opposite party has prayed for restoration to the post of Chief Office Superintendent with all service and consequential benefit within a time frame by the learned tribunal, and that has not been granted by the learned tribunal.
Let us see the prayer portion in that way. To quash the impugned order so and so, to directly restore this so and so with all service consequential benefit. Achha, that is there. Para 8 relief short for achieve. Page number
37.
181.
37 achi. Running page hochi, internal page hochi 11. Amaro Wacom running page hochi 37. So upon कहउछनी केवल क्वाशिंग कर देले अपन, even though there is a specific prayer to direct the respondent to restore the applicant to the post of so and so with all service, and that no such order was passed.
Again, they have filed a CP, my lord. In that CP also, my lord, the learned tribunal has passed an order. That is at page 171.
A miscellaneous application की फाइल करे?
By the applicant petitioner.
कौन फाइल करते हैं?
Opposite party. My lord, may I read, man? Learned counsel heard learned counsel for the applicant, none appeared for the respondents. Learned counsel for the applicant has filed MA number 802 of 2019 for rejecting the order dated 15/4/2019 by which CP file was not registered and dismissed apparently on the ground that the defects were not rectified. But it is submitted by learned counsel for the applicant that he has filed certified copy of the order passed in OA on 1/3/2019 and it was overlooked by the registry. In view of the above circumstances, no notice is required to be sent on this MA. MA accordingly stand disposed of. However, learned counsel for the applicant in the CP, it is seen as that as per order dated 8/12/2017, this tribunal has was the inquiry report order of the disciplinary authority and appellate authority, and no further consequent relief were granted in the said order. Therefore, this tribunal is not satisfied that any ground has been made out to issue notice on contempt. Accordingly, CP is dropped. However, the applicant will be at the liberty to take necessary legal step if he is otherwise aggrieved.
That means from this order, at least it is very clear that what the tribunal intended, that he has simply quashed it, and so far as the consequence and relief is concerned for which you filed the consent petition, that was not entertained on this ground. Have you challenged that order before this court?
No.
Then
That
no.
has challenged. Since liberty has been granted, however, the applicant will be at liberty to take necessary legal step if he is otherwise agreed. What happened, my lord? The disciplinary proceeding was initiated and a order of reversion was passed, and it was confirmed in appeal. I challenged the order passed by the disciplinary authority, that is that reversion order, as well as the appellate authority.
Which was quashed.
The tribunal quashed that. The department authorities implemented the same by page 210. What they have implemented, they have restored me back to my original post from the date of passing of the order.
Level 7.
But the consequential benefit, the salary of that period in that higher post, they have granted that benefit on the date the tribunal quashed the order passed by the disciplinary authority.
Not the
Not from that date. That was the subject matter 210. Since this order I annexed in the CP, the Honorable Tribunal took a view that since they have implemented in letter and spirit, if there is anything remains, then you are your liberty as per law, you challenge or whatever may be as you wish. But the CP, they have implemented the order. They have restored you back to that post. My lord, for that reason, I filed the second OA, claiming that since the order has already been quashed, the disciplinary authorities order, my reversion order has already been set
from the date of reversion to the date of the order passed.
Only that period I claim. And that benefit has been granted. Otherwise, my lord, my stand before the tribunal was, if that benefit will not be given, that it amounts to one punishment, my lord, which has already been set aside by the tribunal.
Correct. Yes,
My lord, at that point of time, he was working as a senior clerk, and the principle of no pay or no work will not be applicable to this case. And my lord, moreover, my lord, when the matter was earlier decided by the learned tribunal, and the same self-issue was before the learned tribunal, and the learned tribunal has passed an order, and that principle of functions officio will be applicable, my lord. The same set of prayer and same set of. So
no, that issue, that though the prayer was made for consequential service benefit in that the first original application, but no such relief was granted, and liberty was granted by the tribunal in that content petition that he is at liberty to raise again. So that is how he again filed the original application. So what is the question of that same set of facts he filed another? It is a totally different thing, that which was not got in the first original application. That is how he got the relief and got the liberty, and so is day in and day out. We ask also the petitioners to withdraw the writ petition and to file, take liberty, all these things, and
first order is complied. Therefore,
if you have complied with the first order, that is reinstating him,
contempt doesn't lie, obviously.
So obviously the contempt would not be there, and that is how the contempt petition was disposed of. But about
my lord, may I submit one more thing, my lord?
Yeah.
My lord, my learned senior has relied upon a judgment of the Honorable Supreme Court in Shivanandan Mahato and versus State of Bihar, wherein the Honorable Supreme Court has been pleased to direct to pay the appellant entire full back wages from the period he was kept out of the service till reinstatement.
What is the decision it referring to?
I have given in my written note of approval. That is also relied upon by the Honorable Tribunal also.
The tribunal order to the Annexure 7. Which paragraph he has relied upon? Hmm.
The written note of submission, page 7, ma'am.
No, he said that tribunal has also relied upon it.
Ma'am.
Which paragraph? अच्छा अच्छा paragraph 5 रे आपण quotation ଦେଇଛନ୍ତି that Nandan Mathur versus State of Bihar. এটা তো just a minute.
From 1311 SEC.
Two 2013-11 SCC 626. Have you got that citation with you?
My lord, I've given in the written note I have annexed.
Written note,
My
nice.
lord.
Written note of submission filed by Mark on the written note of.
Ask, sir.
Date chapter, written note, 8 hours. Please, just take that. We are just coming within 2 minutes. Please place that on.
Let's look at Sivanand Mehta's case, my lord. That fact has been enumerated in para 3. That the appellant was appointed as against the permanent post of clerk in the so-and-so school in 1978. He joined against the said post 79. Subsequently, the aforesaid school was granted permission by the Director of Secondary Education by the officer dated so-and-so for establishment of aforesaid school. The school was inspected by the special board on so-and-so. In the inspection report, the name of the applicant was inadvertently or wrongly shown as librarian. On coming to know about the aforesaid wrong entry, the applicant submitted a representation before the Director of Secondary Education seeking correction thereof. On 1/5/83, the inspection committee submitted its report and confirmed that the applicant had been working as a clerk since the very beginning of the aforesaid school. The school was taken over by the government of Bihar in 1983 in terms of the provisions of so-and-so. I'll add the next paragraph. The next line, the service of the applicant were not taken over as his name was wrongly shown against the post of librarian, which post was not approved. Agreed by the action of the respondents, the appellant submitted a representation before the Director of Secondary Education, Patna and so-and-so, and the director issued a direction to adjust the applicant against the post of clerk in a school in the aforesaid district. In 1984, the Director of Secondary Education, Patna, directed the posting of the applicant as clerk in the high school so-and-so upon transfer of another teacher. However, in later transfers that there was no vacancy on the post of clerk in the district. Thereafter, direction are issued to adjust the applicant as and when vacancy is available.
Para 5 and 6.
My lord. Para 5 is the relevant, my lord. He was kept out of service due to the
right. Para 5 and 6.
He was kept out of service. In my case, my lord, even though the punishment order.
Paragraph 5.
My lord, having heard law and counsel for the parties, we are constrained to observe that the High Court failed to examine the matter in detail in declining the relief to the appellant. In fact, a perusal of the aforesaid short order passed by the division bench would clearly show that the High Court did not even acquainted itself with the fact that the applicant was kept out of service due to mistake. He was not kept out of service on account of suspension as wrongly recorded by the High Court. The conclusion is therefore...
So how your case will come within this?
My lord, in my case, my lord...
You must have been placed under orders of suspension because of the initiation of the departmental proceeding or that criminal case.
That has been set aside.
Oh, set aside, it's all right. That was in factual scenario, that is a difference. That that was a mistake on their part. But it is not a mistake. It is because the proceeding was initiated and it was ultimately the appeal also against you, and that was quashed in the. So how can the ratio would be applicable to you?
My lord, I was precluded to discharge my duty.
Precluded because of the initiation.
In the higher post. In the higher post.
You see, what was the charges against you?
Charges, my lord, there was a allegation there was a liquor party and I was a part of that liquor party.
So
that's why
a departmental proceeding was initiated. You are placed under orders of suspension.
My lord, I think I was not placed under suspension.
Proceed, otherwise.
Your least update just see.
Where is your date chart and
date chart? I am not mentioned that. I started with the initiation of the departmental proceeding. My lord, what happened here, my lord? They have restored me from 2014, the date of order pass. But the benefit has been granted from the Honorable CAT passed the order. Only that.
No, we just wanted to know about that thing. So, keeping in view the ratio let down in. So whether you have not been kept under orders of suspension, you are discharging your duty as such, just a departmental proceeding was also simultaneously running. Just want a clarification from you.
My lord, punishment was imposed that reduction to senior clerk in pay band 1.
Read para 5 full.
Well,
Remaining part is left.
the conclusion is therefore obvious that the applicant would not have been denied.
This is the ratio. This is the ratio.
My lord.
Yes. The conclusion is
denied the benefit of back wages on the ground that he had not worked for a period when he was illegally kept out of service. In our opinion, the applicant was entitled to be paid full back wages for the period he was kept out of service. Well, consequently, the appeal is allowed. The order passed by the division bench is quashed and set aside. The appellant was already been reinstated in service. The respondents are, however, directed to pay the applicant the full back wages for the period he was kept out of service till his reinstatement.
What does it mean by
kept out of service in lieu of departmental proceeding or otherwise. In this case, it is otherwise, wrongly, one post to another post.
One post to another post.
But in your case, it is a culmination of a departmental proceeding.
Departmental proceeding. The punishment order
has been passed.
The punishment order passed in 2014. I was reverted to my post in 2014. From 2014 to 2017, the order passed by the Honorable Tribunal. During that period, my lord, I was in fact allowed to continue as senior clerk. But that's that, my lord, one preliminary inquiry was conducted. My lord. My lord. My lord. Starts from page 162. Four series. 161, the order start. The paragraph 4 is the 648 of 2014.
Why this particular number is mentioned in every way?
260 is the code number of Kotak bench.
Now, that original application will challenge the disciplinary order, first order, and also the
Appellate order.
Now, what is the finding of the line there?
My lord. Last but not the least, since the original complaint as per Annexure 1 submitted by Mr. S. Eka moves around the misconduct of Sri S. Nag, tagging for the present applicant in the entire episode become a afterthought, and there is no legal basis for omitting such fact of group consumption of liquor in the office in the initial report under Annexure A/1. This is just like non-mentioning of name of the culprits in the initial affair and subsequently introducing a different person into the scene of occurrence.
had the initial report on the annexure A/1 submitted by the SSC disclosed about consumption of liquor by the office staff, the matter would have been different. The whole allegation was around the conduct of Mr. S. Nag in putting his signature, and the initial allegation against the appellant was allowing Mr. S. Nag to put his signature, which allegation could not be proved by the inquiry officer. Taking a cumulative effect, the entire scenario, it is undoubtedly clear that holding the delinquent employee guilty of consuming liquor has not been proved legally, as the inquiry officer reached to the conclusion basing upon the preliminary inquiry report, which cannot be taken into record, hence order. And the preliminary inquiry report was prepared. Basing upon that, the punishment, the present respondent opposite party has been found guilty by the inquiry officer. On that score, my lord, the punishment order as well as the appellate authority's order was set aside, and it was implemented by the department. That yes, you have been restored back from the date of passing of the impugned order.
Mr. Gochai. So once it is held by the Learned Tribunal that in the first one that the delinquent employee is not guilty of consuming liquor, and he has been found guilty only basing on the preliminary inquiry report, and it should not have been done. So therefore, it goes to the root of the matter. And therefore, when you kept him out of the service for that post, so whether in such a scenario, what is the question of his fault that he would not be entitled to get the salary for that period?
My lord, at that time, he was working as a senior clerk, my lord. He was not kept out of service. Because, my lord, kindly have a glance to
he kept out of the service for that particular post for which he is claiming now. You have given him another post he was holding, which carried a lesser scale of pay. So he is now claiming that scale of pay which he would have otherwise got had the departmental proceeding would not have initiated against him. So that is his grievance actually. So now and you have not challenged this meeting of quashing of the disciplinary order as well as the appellate authority's order. So it has attained finality, not only attained, but you have also acted upon it and has given him the due post as for that order of the Learned Tribunal. So how do you now deprive him about the benefit of the amount which is entitled to?
My humble submission is that, my lord, in the earlier order of in OA, there was no specific direction.
There was no direction. That is the reason the second OA.
I know.
That is how he got the liberty in that contempt petition and filed the OA. All right,
without specific direction, no retrospective benefits can be granted.
Writ petition has been filed by the Union of India challenging the order passed by order dated 21/6/2021 passed by the London Central Administrative Tribunal Cuttack Bench in OA number 816 of 2019 in allowing the original application filed by the opposite party Samuel Ika and also the order dated 19/10/2023 passed by the London Central Administrative Tribunal in RA number 260/0009 of 2021. In dismissing the review application filed by the petitioners. The factual scenario of the case, in short, is that এটা হচ্ছে impugned order of para 7 number. In short, is that you put this paragraph number 2, preparation kari. Then the petitioners, on being noticed, appeared in the case and filed the counter affidavit, wherein it is stated like this. You put this paragraph number 3. Impugned order. Impugned order था annexure number 7. Counter affidavit of flotation. It appears that when the first original application filed by the opposite party was allowed in way number
648 of 2014.
Number 260/648 of 2014 by order dated 8th December 2017, quashing the inquiry report dated 25/3/2014 and disciplinary order dated 15/4/2014 and the appellate authorities order dated 11/7/2014. No specific observation was made with respect to the prayer made by the opposite party. Where is your original application that with respect to the opposite party, with respect to grant of all service and consequential benefit within a time to be framed by the London Tribunal. And when the opposite party filed the contempt petition by CP number 260/65 of 2019, the London Tribunal by order dated 1/10/2019, though has been pleased to hold that no ground has been made out to issue notice of contempt and accordingly dropped the contempt petition, but gave liberty to the opposite party to take necessary legal step if he is otherwise aggrieved. And accordingly, the second original application, that is OA number 260/816 of 2019, was filed, in which specific prayer has been made by the opposite party to modify the order dated 12/9/2018. 12/9/2018 means is way re.
No, my lord. That is the implementation order.
Acha, under annexure A/6 সেটা দেখি দেব annexure A/6 টা কোন তার পেজ 181 রে আছে
210
হ্যাঁ
210 রে আছে
আচ্ছা 210 দেখতে to the extent that the opposite party shall be allowed to draw his salary against the post of office superintendent level 7,
chief office superintendent
level 7 from 16/4/2000 14 instead of the order passed by the Learned Tribunal, that is 88/12/2017. Inter alia to for further direction to the petitioners to restore the opposite party to pay the post of Chief Office Superintendent with effect from 16/4/2014 with all service and consequential benefits within a time limit. The prayer of the petitioner, opposite party, was allowed, and the operative part of the order is quoted herein below, paragraph 12 and 13. It appears that a review petition was filed by the petitioners by RN number 9 of 2021, and the same was disposed of by the Learned Tribunal by order dated 19/10/2023, and the Learned Tribunal has been pleased to hold as follows. Put paragraph number 8 and 9 of that review petition order, which is at page number 239. Stop. It seems that while passing the impugned order dated 21/6/2021 in OA number 816 of 2019, the Learned Tribunal has taken into account the ratio laid down by the Honorable Supreme Court in case of Sivnandan Mathur versus State of Bihar and others reported in 2013-11 SCC 626, wherein considering the factual scenario of that case, it has been held that since the appellant in that case was kept out of service on account of suspension, then he could not have been denied the benefit of back wages on the ground that he had not worked for the period when he was illegally kept out of service. And therefore, the direction was issued in the said case. It was held in that case that the appellant was entitled to be paid full back wages for the period he was kept out of service. Mr. Guchayatland Central Government Council on the argued that here the petitioner was not kept out of service, but on account of initiation of the departmental proceeding, he was ultimately reverted. Who post was here?
Senior clerk.
Senior clerk. And the see you fast order to kodala. We कितने number page है?
Page 208.
208 hour को. And ultimately, the inquiry report was against him and the disciplinary order was passed. So also the appellate order, authorities order was passed. And when the same were passed by the Learned Tribunal, he was taken into service, and therefore he is not entitled to get the consequential service benefits. And therefore the order of the Learned Tribunal passed in the OA numbers one, so also the review petition should be passed. On a careful analysis of the first judgment, which was passed by the Learned Tribunal, we find that the inquiry report, disciplinary order and appellate authority order were quashed and assigning the reasons therein. এই প্যারাগ্রাফটা কোট করছিলে কি সেইটাও কোট করে দেবে মধ্যে যেটা ক্লাস ই নଥିଲା যেটা ইয়ে সেটার মধ্যে প্যারাগ্রাফটাকে কোট করে দেবে প্যারাগ্রাফ নম্বর 5, 6 and 7 and 8 পুরোটা কোট করে দিলেন এই যেটা ওয়ে নাম্বার 816 of 2009 है that is available in page 30 আরম্ভ হয়েছে সেটা page number 26 বোধ আরম্ভ হয়েছে page number 26 আছে তারপরে স্যার অপারেটিং পার্ট আউট করে and the Learning Tribunal is quite justified in holding that
Two 226, 225 and 226 is the operating portion. 225 paragraph 12.
In holding that the that claiming pay of the Chief Office Superintendent with effect from 15/4/2014 till 8/12/2017.
Date of reversal to date of the judgment. Date of reversal to date of the judgment.
That is date of reversion to date of judgment does not at all come within the scope and ambit of consequential benefit and right and claim of the opposite party is clearly covered by the earlier order passed by the tribunal, and therefore the petitioners are duty bound and legally obliged to grant pay in favor of the opposite party, which he is entitled to in his capacity as Chief Office Superintendent with effect from 15/4/2014. Because of the initiation of the departmental proceeding, since the opposite parties was reverted to the post of senior clerk, and ultimately all those proceedings have been set aside, then the claim of the petitioner, the claim of the opposite party is quite justified, and we find no fault, no illegality or perversity in the impugned order passed by the Learning Tribunal on 21/6/2021, and also in the order dated 19/10/2023 passed in the review application. Therefore, we are of the view that there is no merits in this writ petition, which is accordingly dismissed. Yes.
Simple 32 matters. Tender matter was tendered on Friday. Matter number 32. 32. Lordship only wanted to know that whether any contract was executed.
You were supposed to get.
Yes, yes, Father. I got this.
This is a recognition matter which was passed over. Item 9. It is for you.
Contract was signed.
Contract was signed.
I will submit on that. I will submit on that. I'm ready for
That's
that.
the only
Lordship,
point, my
kindly
lord.
go
I'm
to the
showing
document,
you.
I will submit.
I'm showing you, Lordship. Lordship may kindly see
Where
the
is
first
contract?
flag. The first flag which I put, my lord,
Yes.
that is 2122. Now, Lordship may kindly come to next page 25, that is the second flag. That is for 2223.
Or is 23.
2324, he did not give any contract paper. He only started, my lord, giving these invoices.
No, that is not the fact, but I'll submit on
That
that.
was not the fact.
There was no contract.
It is your document they are producing.
No, Lords, I will submit on that.
And
Lordship,
the
both for the document, I will submit.
tender conditions categorically stated that you need to
If you want
produce
to
the
say
contract.
anything, you can say it must have been handed over to you. It is your document.
My lord.
Is it correct or wrong?
It is submitted.
No.
My lord.
And the same set is correct.
Same set, Lords. On the last occasion, I will submit it.
Please answer.
My lord.
Insofar as 2220, 2122 and 2223,
My lord.
you have supplied the same copy.
These documents along with this 2018 order we have
And
supplied.
what about the last year, that 2324?
2324, this 2018 and 2022 order which is continuing.
This much you have supplied?
Means that we have, I am not able.
That's the question. That's the question.
Giving it.
Can please go through it. That is-
Invoices are there, my lords.
He only gave the invoices and he is
See,
now
you are,
relying.
you see,
not the
please
issue.
appreciate, your bid has been cancelled
My lord.
on the ground that for first 2 years you have supplied the contract,
My lords.
but the last year you have not supplied the contract.
That is what
He,
they say.
he
Yes.
has filed this. These are the
My-
documents which you have filed.
If you say that in addition
Let
to
him
this,
show for this honorable court any contract. At least before this honorable court.
Sure.
Any paper which is having now.
You just go through and tell us subsequently.
No, you have seen that one.
this is a handover code, sir.
देखिए
Read it.
आज कोरिया
No, read it. Only
ପହରଦିନ କରିବେ ନା
Any did your lordship.
any contract, let him show you.
Let the young man
Sir,
Anything which
one chance.
I will take. I
He
will
has to
take
take
time.
instruction
Yes,
from
yes.
this party, of course. You cannot say, I did that, no, I have not filed.
Absolutely.
So.
you both the seniors can't push him to the wall. You know,
No, he cannot, just let him just.
Young man is.
Any short date on Wednesday also.
On Wednesday,
Just take.
what's the pay? Grant us
Only
the
this much, huh? You have
Only this
answered.
much. Only one point your lordships may kindly consider. I'll come get back on this point on Wednesday.
Don't argue half-heartedly. Don't do
This
that.
mill argument is not.
Well, it's on Wednesday.
Lekon, the, Mr. The party, and senior advocate appearing for the opposite parties number 2 and 3 has produced the copies of the relevant contracts executed by Messrs. Atal Plastics with Central Oblique State Government Organization Oblique PSU Oblique Public Listed Company for the financial year 2021-2022 and 2022-2023, along with the bid documents in support of having supplied the same during the above 2 financial years. But it is stated in the written instruction received from the company secretary of Odisha State Medical Corporation dated 11/7/2025 that the petitioner, the bidder has failed to supply the relevant contract document sought in support of the proof of supply for the financial year 2023-2024. And the petitioner has only furnished the copies of several invoices against the supply of non-oven bags to private limited and public unlisted companies which doesn't meet the requirement of clause 18.8 of the tender documents. And that the tender committee, after careful evaluation of the bid documents of the petitioner, rejected the bid as per clause 18.8. Stop. The documents filed by Mr. Tripathi are taken on record. The copy of the documents have been handed over to Mr. B. Vaibhav, Land Counsel appearing for the petitioner who wants to obtain instruction in the matter, and 6 for an adjournment. List this matter. S.Mishra Mahapatra, Manas Mahapatra, Land Senior Advocate for the opposite party number 4 and 5 is present. Put up this matter on 16th of July 2025. Let us not delay the matter.
No.
Tender matter.
Can it be allowed within 20 or 15?
No, you just made a member.
So we're granting liberty, my lord, will make it nice.
So it's an interim order to continue till the next statement. Plus there's an interim order in this one.
Right, the interim order dated sponsor shall continue till 16th of the.
Item number 9, Manoj.
कितने number item है वो?
Item 35, your lordship. The last item on my lord's board.
What do you want?
That is that OSFC matter, your lordship may kindly remember, wherein your lordship were directed that the auction may proceed, but it will not be finalized. Pursuant to that auction, a bidder had participated and has been selected as the highest bidder. Petition is there on record. Your lordship may kindly permit me. I'll take notice to that party.
What is that interim application?
That interim application, your lordship. 11542 of 2025, your lordship.
And cancel the Devata. Right, but IN number
Flag E,
11542 of 2025 is an application filed by the petitioner for amendment to increase Messrs. Feeders Electric Engineering Limited as opposite party number 5. As being the highest bidder, he has been selected, right? Yes. Selected. The Land Council for the opposite parties has no objection to the prayer made in the interim application. Accordingly, the prayer is allowed. So and so is permitted to be included as opposite party number 5, and amended cost title to be filed.
I'll file it in the course of the day.
File कर दीजिए.
Court day, your lord.
File करो by day after tomorrow.
I'll file it tomorrow, your lordship.
All right. By tomorrow. So you file, but once you don't file, it has to again come so that we will issue notice. We cannot, that these are all, if you have got that, why are you not? This is a formal order.
My lord, this is a formal order.
You should have got that. Otherwise, you do one thing. We are bringing this matter on
tomorrow, your lordship.
No. Tomorrow it is another bench is there. We are bringing it on 16th.
Day after,
just you file that consolidated cost title so that notice is to be issued to that opposite party.
My lords.
Put up this matter on 16th of July 2025 with the consolidated cost title, if any, be filed by the Land Council for the petitioner. Yes.
Interim orders them that may kindly be continued.
The interim order is there.
4/7/2025, your lordship.
The interim
sale shall not be
finalized
without leave of the court.
After the Ketla pass is 4/7.
I have also filed a IA for seeking leave to finalize the.
Decide the matter.
The interim order dated 4/7/2025 is extended till the next date. That is on 16th of July 2025.
Much grateful.
Yes, Mr. Mukherjee, what is the matter?
Yes,
May I pardon?
Item 9.
Starting of my Lord Senior. Item 29, madam.
petitioner is there. I seek only 10 days time to file the counter affidavit. So for the last chance, I have taken earlier matter.
Who is for the Punjab National Bank?
I am.
Acha, you are. And who is for the petitioner? Acha.
Twice they have took time. They're requesting that no lobster there. He has adjourned.
For 4 months.
So your lordship may fix up a date.
Okay.
Because
Item number
it's difficult
29
to
is from Mr. Ranjan Kumar Biswal and counsel appearing for the Punjab National Bank. 10 days time for filing the counter affidavit. Mr. Surup Kumar Patnaik and counsel for the petitioner is present. Put up this matter on 25th of July 2025. Counter affidavit, if any, be filed in the meantime, serving a copy on Mr. Patnaik. Okay. Purchase the 25/7/20. Yes. Yes, Mr.
Yes,
Item number 9.
The erstwhile landowner executed two leases in respect of the properties of his properties in favor of Hindustan Petroleum Corporation, wherein two retail outlets have been established. The leases were executed in
You have already entered appearance for the.
But I have instruction to appear. Let this copy.
You give a copy, Mr. We can take up day after tomorrow. Let him take instruction. You are appearing. You will appear for UCO Bank.
No.
Right. All right. Give the name so that sponsor who submit that he has the instruction to appear for UCO Bank. The opposite party number 1, and he will file his wakalatnama by tomorrow. Let a copy of the writ petition be sought on the land council for the opposite party number 1 during court
of the day.
In court of the day. Let this matter on 16th July, day after tomorrow.
I may be pardoned to mention, my lord. I may be pardoned to mention, my lord, item 28. I am appearing on behalf of Union of India. My appearance may kindly be recorded.
Item number 30. Yes, just a minute. Item number 20. It is the Mohammed Ridwan versus State of Orissa Electricity. Item 20 is writ appeal number 80 of 2020.
No, you're talking about 29 or 20?
28, my lord, 280.
28, Mr. Lenka is here. He was just. So it will just come day after tomorrow. So we are not taking out of the list of all these matters. It will be in the top. So we take up this matter, right?
30 you are saying.
Lordship, matter pertains to the implementation of second judicial pay commission report. The assignment. The assignment is of Lordship. It has been inadvertently listed.
Okay.
The assignment is number 20.
Court number
25, Your Lordship.
The land council for the petitioner submits that the assignment.
There is a flag A.
Flag A, it was listed before the Honorable Single Judge Bench.
Let's see.
It was listed before the Honorable Single Judge Bench. Then it was placed before the Honorable Chief
Justice. It is assigned to this bench, flag A, just see.
Lordship.
Division bench presided over by Justice S.P. Sahoo.
Okay.
That is there, so we can.
Your Lordship. Then it comes.
It will come day after tomorrow.
Notice for judgment, WPC 26694 of 2024.
The writ petition is allowed and the MA is restored to its original file to be decided by the tribunal.
I agree. Yes.
Yes, criminal appeal lordship. If others are in custodial lordship more than 3 years alone.
Quickly list item number 1.
Negligence. Here the applicant challenge the judgment dated 31/5/2025 passed by the London First Additional Session Judge Corey, wherein the London trial judge was pleased to convict the appellant under section 302 and 34 of IPC and the 27 of Arms Act. On the
So 9% face trial.
Yes, my lord.
And 6 of them have been acquitted. 3 have been found guilty, and there are 3 criminal appeals.
Lordship, there are 3 equal.
Right. Admit call for the trial court record, interim application for bail and sterilization fine to be considered after receipt of the trial court record. Diffusion copy to be supplied land counsel for the state in the meantime. Yes.
Item 2.
To Mr. Pradhan, it is life permission.
My lord.
All right, delay condom and admit call for the trial court report for the further.
Item 3.
It are received in time, admit. Counsel engaged for the. Yes.
Item 4.
May I please.
In this case, my lord, the appellant is in custody since 14/3/2012. The appellant.
Just a minute. Your bail application was rejected on merit earlier.
Right.
On 6/2/23.
Right.
Then you are granted interim bail for a period of 2 weeks on the ground of your younger brother's marriage, right?
Yeah.
And you surrendered after that. Then we asked the state council to produce the custody certificate about the criminal antecedent and his conduct during interim bail period. No problem. How many years he is in custody?
Actual undergone 12 years, 1 month, 15 days. And so far, remission is concerned, 14 years, 4 months.
Remission Mr. is 14 years.
14 years.
Actual is 12 years.
12 years.
How which jaitla kisi gandagol karna hai?
No, man.
Or the land council for the petition, land council for the state. The land council for the state has produced the custody certificate from Superintendent District Jail Balasore. which indicates that including the cost of remission period, the petitioner has undergone 14 years, 4 months, and 18-day sentence. The report is taken on record. Another report has been produced from Inspector in charge of South Punta Police Station, Balesur, which shows that there is no criminal antecedent against the petition. The report is also taken on record. Considering the and counsel for the state was submitted that the earlier bail application of the petition was rejected on 6/2/2023. And thereafter he was granted interim bail for a period of 2 weeks by the order dated 26/11/2023. Considering the submission made by the land council for the respective parties, the period of detention of the petitioner in judicial custody, and since the petitioner has not flouted the terms and conditions of the interim bail order, and the absence of any chance of early hearing on the criminal appeal, we are inclined to release the petition. And keeping in view the late case, we are inclined to release the petition on bail. Lord.
What about the connected appeal?
Connected appeal.
That is a serial.
Vishwanath Sahu.
Yes, ma'am. Serial converted to CRLM. One of the co-accused persons have been acquitted. Against that acquittal, I have filed this.
No, what is this? Have you filed any bail application?
No, my lord. It says.
All right, next.
Against acquittal.
Highly.
That is informants.
Yes, item 6.
Item 5.
Item 5. Anything equals to
302 and 376. Thank you so much. You can custody since.
1 minute, madam. Wait. It has come. What?
When I say 11 years, 7 months and 24 days, and the remission is concerned, 14 years, 8 months and 8.
14 years, 5 months, 58.
Mr. Devson Rajapaksa. The present appellant has filed the interim bail in view of death of his father-in-law. He was released for a period of 3 months by order dated 12/8/2024, Your Worship.
Surrendered.
Yes, Your Worship. The surrender.
I have obtained.
Surrender certificate.
କେବେ ଏକ୍ସପାୟାର କଲେ ବାପା? ବାପା କେବେ ଏକ୍ସପାୟାର କଲେ?
On 10/7/2025.
10/7
Expired.
Annexure 2 is a death certificate, Your Worship. Oh. Okay.
ଓ ବାପା ଏକ୍ସପାୟାର କଲା ବେଳକୁ ଆପଣ ଥିଲେ? How long leave ରେ ଥିଲେ? For a period of 14 days.
Yes.
What's the custody period total?
13 years, 7 months.
যদি এটা গুলো হচ্ছে সেটা হচ্ছে পিরিয়ড তারা Here number so also there is an application for interim bail on the ground that the father of the petitioner has expired on 10/7/2025. The Land Council for the state has obtained written instruction from IIC Town Police Station dated 13/7/2025, which also indicates about the death of the father on 10/7/2025. The written instruction is taken on record considering the submission made by the Land Council for the respective parties. The government's taken in the interim application and the document produced by the Land Council for the state. We are inclined to release the petitioner on interim bail. The interim bail period shall start from 15th of July 2025, and the petitioner shall surrender before the London Trial Court on 1st August 2025. Put of this matter in Louis commencing from 11th August 2025. The Land Council for the petitioner shall produce the surrender certificate on the petitioner. Yes.
Item 8.
Lordship, I phrase the order should be.
Yes, you'll get it during course of the days.
Lordship.
Item 9.
Item number 8.
Item 8.
Yes.
Can you see the last order? 24/4/2025.
Because surety.
He's not unable to.
No,
So that is in
copies of the
be posted for hearing.
Also, so that means you for hearing later all that.
Yes.
So radio chandi. 2017. ठीक अपन भी रेडी अछन तो ठीक है सर जो इटा नवा नेक्स्ट मैटर दो
Item 9.
not really.
Yeah, item 9, I have a prayer to make. The file has a mistake. Can I?
इंटरिम बिल कौन सा ही फाइल करते हैं
Interim bill I have
That is for bail only. That is for.
no the interim bill is 1370
It I military for file for an interim bail military for a period of 15 days. He is never released on bail.
अरे
What's the ground of interim bail? Grounds one is that military
never released on bail तो फाइल को ठानते कितने दिन रानी और interim bail 15 दिन पे ही कौन दरकार माने कौन ଗୋଟେ reason हो तांदा 15 दिन पे कौन एंती बुलिए कि ना से हो जीवे ना कौन कौन पे 15 दिन पे कौन bail
military grounds are military the petitioner was custody more than 13 years. As per regular bail you can ask for. Why?
We do it unnecessarily. Look on, the land counsel for the petitioner seeks permission to withdraw this application to file another interim application for bail and not disposed of as withdrawn. Yes.
Item 10.
You know the password next.
Item 11.
May I please? Appellant is in custody since 30th December 2013. Near about 12 years now.
Any custody certificate?
Allow, please.
IO number so this is an application for bail and counsel for the appellant submit that the appellant is in judicial custody since
30/12/2013.
30/12/2013. Land counsel for the state seeks some time to produce the custody certificate as well as to obtain instruction regarding the criminal antecedent defendant against the petitioner. So please conduct inside the jail. Put of this matter or his evidence. Yes, next. Who does?
I don't take.
Phone.
Conviction for life violence. PW3, the victim.
Agu rejected ji. Agu rejected ji on merit rate.
Interim bail was granted and he has surrendered in right time. 8/4/25 he has surrendered, traveling the same.
ଯେତେବେଳେ ମେରିଟରେ ରିଜେକ୍ଟ ହେଇଛି ବୋଲି ଲେଖା ହେଇନି ଖାଲି ଦିଆ ହେଇଛି ବେଲ ଯାଇଛି ତାପରେ ଆପଣଙ୍କର ବାପାଙ୍କର ଡେଥ ପାଇଁ ଯାଇଥିଲେ
Interim bail he has surrendered on 8/4/25.
what is your total period and what is your
Custody since 3/2/2018 he is in custody.
What is the conduct during that interim bail period? You were granted twice.
He was granted, he has no adverse remark.
What is your instruction, madam?
I have to obtain instruction regarding the conduct.
Ajay, এটা POCSO Act এর কোনো conviction is না?
The POCSO is there. She was only 15.
building up a story.
No, no. Corpus statement accused me lot. They question the motive leading to discovery Korala before being the police.
And the defense which you are saying, whether it is reflecting in the record somewhere or the other.
काली रात्रि नंबर
Story.
All witnesses will not all the witnesses will some
बाजी जीव यदि बाजी जीव काले
no witness are one there. There is a matter.
What was your defense?
Defense matter the witnesses who have stated somebody have declared hostile Millard. And PW19 with the only witness Millard, who is the grandson of the deceased Millard. He Millard said that I have seen that while after killing the mother, that
grandson kete PW
Millard
PW kete
say 9 Millard only 9 खाली गोटे statement अन्य मान को माने discard करी कहछि others are saying not I have not had
4, 7, 9 would be the relevant witnesses.
4, 7, 9.
7 and 9. And accused statement रे question number 2 रे सान पूछन जे मुच्छ कथा मु सदन घरे नथिली. That is the defense.
4, 7, 9 no कौन है?
So sir, I will be placing
my lord I'm supply core Millard. That is the name is Nursingha Jenna. Paragraph 2 Millards. On the relevant day at 2:30 to 3 p.m., Maggie died. Maggie means the deceased name is Maggie died. Being killed. We were playing cards, and after hearing sounds, we came to house of Maggie and found Maggie was murdered and lying inside the house. I heard from Krishna Jenna, son of Vipra Jenna, said that Hani Pokai Polaile. That is paragraph number 3, Millard. So it is the cross sanction. That means Millard he has stated a difference.
7 number question.
After 10 to 15 minutes, my wife arrival at the scene of occurrence, police arrived there.
No, 7 I
it is a fact that I have not stated before the police that I found cut injury on the neck, shoulder and right hand of the major.
It's a Kosaki Purkundi.
So that's it. Coil from the potable 4 million.
PW7 question. They stated that he heard a sound and then after some time saw you escaping with
immediately there.
Bloodstained cutlery and there was blood in the hand.
Paragraph 2.
PW4 statement next one conviction for the PW4 million I've read million that they have here not touching anything.
9 PW9 point.
You lots of people have sad body mill.
That's what sir.
Again,
some prior
PW7 million. She coila paragraph 2 occurrence took place on 11:28 at about 2:30 to 3 the deceased was at her house. Ajay Das, Nursingha Jenna, Harish Jenna and Vijay Jenna were playing the cards in front of the house of the accused and deceased and I was watching those playing cards. On the relevant day of the time of the accused, person came on the road and entered into the house where the mother of the accused, Rajendra, was standing and after some time, I heard a sound and after some time, I saw Rajendra was escaping from his with his blood distanced cutlery and also blood on his hand.
In hand.
Well, that is the PW4 किंतु किसी को नहीं जिसे playing cards में 7 किंतु एक 8 तक लगा लॉर्डशिप काइंडली have 8 है no से टिके slightly difference था कुछ
तो सोडा से फाइनल ईयर देखा जीवा
my submission respect to me lord
9 तर motive भी कुछ and post अकरल
and me lord just a permission me lord appellant number 2 me lord who was the appellant separate file separate appeal who lordship granted to the bail and my lord application of continuing my lord since madam appellant some general things my lord never my lord committed a murder to his own mother my lord he has not my lord but to save his why my lord he has said
where from you getting
but it was a circumstantial evidence that evidence my lord there is no eyewitness to the occurrence my lord court confide to that तास खेलुथिला हम सुनिया पाइलु मर में
नहीं नहीं मोटिव न तापर आपण दौड़ी पळेले समान डेड बॉडी देखिले आपण यदि XYZ मारला त आपण पुओ आपनर कंडक्ट जावा कथा सेया हेनी रादर आपण ही एक्सप्लेन करिवे जेतले घरे आपण थिले आपण मा थिला मा होमिसाइडल डेथ केमति हला ଆପଣ କଟରୁ ଯଦି ପଳେଇ ଯାଉଥିଲେ କାଇଁ ମା ତ ମରିକିନି ପଡିଲା ଯଦି ରାମା ଦାମା ସାମା ତାକୁ ମାରିଛନ୍ତି ତାହେଲେ ଆପଣ କଣ୍ଡକ୍ଟ ରାଦର ହବା କଥା ପ୍ରେଜେନ୍ସ ରହିକିନି ମାକୁ ନେଇକିନି ଯିବା କଥା ହସ୍ପିଟାଲ ଆପଣ କେମିତି କଟରୁ ଧରି ଓଲଟି ଦୌଡ଼ି ପଳଉଥିଲେ ରକ୍ତ ଦାଗ ଇଏ ଲାଗିଛି
PW9 lordships ତାକୁ statement IO କରିଛନ୍ତି ସେ କଣ କହିଛି lordship kind have PW17 the IO what he has stated before the court my lord IO cross that pair I have filed the deposition case page number 39
କେବେଠୁ ରହିଛନ୍ତି କେବେ
my lord
2019.
ଆଉ ଟିକେ ରୁହନ୍ତୁ ଦେଖିବା
ସେଟା ଖାଲି ଟିକେ ସେ କଣ କହୁଛନ୍ତି ଖାଲି ଟିକେ ଦଶ ହାତ ଗ୍ଲାସ
এটা ପୂଜା ପର୍ବ
PW17
after ଦଶହରା
ଆଉ ଗୋଟେ ଖାଲି ଏଇଠି ଖାଲି ଗୋଟେ ଖାଲି କପିଟା ଖାଲି
ଆଉ ଗୋଟେ ହେଲେ ଆଉ ଥରେ ରିଜେକ୍ଟ ହେଇଯିବ ପୁରା
ମୁଁ ମଦର ଦେଇଦେଉଛି ୱାଇଫ ର କେମିତି ବେଲ
ଇଏ ନମ୍ବର ଷ୍ଟେ ଅଫ ରିଏଲାଇଜେସନ ଅଫ ଫାଇନ ଏଟାକୁ ଆଲାଉ କରିଦିଅନ୍ତୁ
ଆଉ ଏଇଟା କପିଟା ଦେଇପାରିବି ନା ଏଟା ରହିଥିବ ଯାହା ଯେ
କରିଦେବେ କହିବେ ଆଜି ଏଇଟା ଅର୍ଡର ହେଇଗଲା ଫାଇନ ଟା ଷ୍ଟେ ହେଇଗଲା ଆରଟା ବିଚାର କରିବା ପାଇଁ ରହିଲା ଏଇଆ କ୍ଲାଏଣ୍ଟ କୁ କହିଦେବେ ୟେସ୍ ନେକ୍ସଟ
ବେଲଟା ଲାଇଭ
ବେଲଟା ଲାଇଭ
Item 13. Item 13, my lord. Item 13, my lord, kind taken up 2 days after, my lord.
2 days କାଇଁ ଭଲ ଦିନ ଅଛି ସେଦିନ
ମାନେ kind taken up 2 days after.
2 days after next week ଆସିବ yes
Item 14.
Item 49 for next week
ଭଲ
Item 15.
In this case, my lord, the husband committed to murder his wife, my lord. The elder the 3 months interim bail is allowed. Legal section related to produce passport certificate on this letter.
ମେରିଟରେ କେବେ ରିଜେକ୍ଟ ହେଇଥିଲା ଆପଣଙ୍କର କେବେ ରିଜେକ୍ଟ ହେଇନି ଇଣ୍ଟରିମ୍ ବେଲ୍ କେମିତି ଗଲେ ମାନେ କଣ କାରଣ ଇଣ୍ଟରିମ୍ ଆଚ୍ଛା ଇଣ୍ଟରିମ୍ ବେଲ୍ ଯାଇନାହାନ୍ତି
ନା ଟୋଟାଲ ନାହିଁ
ଆଚ୍ଛା ତ ଡିପୋଜିସନ କପି ଅଛି P02 case
the conviction on eyewitness
eyewitness किए
informant wife
कितना नंबर
P5 page 49
P5 डॉक्टर की
डॉक्टर P8
PM डॉक्टर
8
गोटे गोटे eyewitness
ଆଉ ଜଣେ 10 P10
तो 5 10 होउछन दीटा eyewitness और 8 होउची PM डॉक्टर या तो partial to one project with high coherence due to government. The PW 5%. Accused dealt 3 blows by means of a tabal on the head of my husband, for which my husband sustained severe bleeding injury and died at the spot. Then dispute हिला. अच्छा 8 नंबर out of 10 number. Minor. What on? This is the two. This is like my grandfather. Accused Vichitra is my elder father. Oh, they are related to each other.
Related. Actually, the real fact has been suppressed.
Just a minute. 3 blows has been given by means of a towel.
Injury.
जो इंजुरी देखी थी दीटा इंजुरी क्रॉस एग्जामिनेशन ने सी आनिले जेटा पॉसिबल बाय हार्ड एंड ब्लंट ऑब्जेक्ट नॉट बाय शार्प कटिंग वेपन एटा 26/7/2019 रे डिपोजिशन देला परे 13/1/2021 रे ताकू गोटे रिकॉल करी तादेरे गोटे आनिले जे गोटे क्वेरी हिला आउ से ताबल को पठाए थला से ओपाइन देतला जे हेड इंजुरी possible value द्वारा authorized by 26/7/2019 this assault by this tabal was getting falsified because of this evidence given by the doctor, but this was brought subsequently.
Statement of eyewitness will clear and present to that effect. About the assault, he assaulted, but that is deliberate attack. The doctor says something with the by created his belief in the mind, but
Parietal bone and outer
the minor has examined, he has also stated like.
How many years you are in custody?
13/11/2017. That's 7 years, 8 months. So far as a minor
से छुआटा कौन छुआटा कोट रहउची जाई मनोबल करितो ना से छुआटा को ता एविडेंस दे
Saheli actually has not seen, she has not seen.
सिगुडा को हमें पछर
But at this stage it is examined and cross-examined.
छुआटा जो देची एविडेंस PW10 हिसाब
10
6 वर्ष छुआटा के बहुत सी
Statement of PW5 में description of additional embellishment.
ये माने यूज बड़ा
बड़ा किंतु IO 21 the investigating officer and he, before the investigator said I had to listen, that's it. And IO in his depositional state the Puja Benian who is the surrounding neighbor has not seen the occurrence. And Puja Benian who is the eyewitness, he is the far away, half kilometer of the occurrence. So far as the
Minor
discrepancies are not to be decided at this
Land
time.
and Council for the state has produced
And there is more
the-
contradictory, my lord, the statement.
custody certificate as well as the criminal antecedent report which are taken on record. The Land Council for the state took some time to obtain instruction about the status of PW 10. That is an eyewitness to the occurrence. Put of this matter. Of the August muscle of the sorry. Yes, next.
Item 17.
Please, madam.
I know theoretical state relation of puncher allowed. No.
My lord, here the petitioner is languishing in jail custody since 22/4/2019. Here, the incident leading to that death, that both the deceased as well as the present petitioner, they belong to the one village. Whereas both of them also went to a nearby place to observe, to see that Ramlila.
Your bail application has been rejected.
Earlier, sir, earlier rejected, yes.
21/8/2023.
Sir.
ବର୍ତ୍ତମାନ କଣ merit କଥା କୁହନ୍ତୁ
Sir, only there no weapon has been used, nothing, because both of them are also quarreling because the deceased was in a drunken condition, unable.
ଆପଣଙ୍କର bail on merit reject ହେଇଯାଇଛି by a division bench.
Sir.
So you could have gone to the Honorable Supreme Court against that. We are not here to review of the earlier order. ବର୍ତ୍ତମାନ period କେତେ ରହିଲାଣି?
More than 6 years.
କାଇଁ custody certificate କାଇଁ?
22/4/2019 is also in custody.
Custody certificate ଅଛି କି ଆପଣଙ୍କର?
He has not granted bail.
Custody certificate ଆଉ ବାକି criminal antecedent ଆଣୁ and jail conduct ହେଲା. Yes. Next.
Item 18.
Where the appellant has been guilty for the offense under section 3762.
11/8/2023 rejected. कौन change किसी नहीं?
Custody. Appellant is a young boy. At the time of occurrence, he was only 19.
19 years.
19 years. 19. And the victim was around 14 to 15. The POCSO Act is there. No separate sentence has been.
Unfortunately, thrice it was listed, but not admitted. So moto, my lord, was admitted on 3/4/24. None appears there. I have filed my power, and today this has come.
It has come for consideration of the bail application.
And stay was not the.
कौन है ना bail application move करी ना?
Yes, yes.
Move it. Have you supplied the deposition copies?
Yes.
So what is the
No,
case?
I have not supplied. My
What is the case about?
case is about that.
Deposition. Oh, deposition they na di.
No, today I have just.
Like IA the numbers one to is an application for bail. Let the deposition copies of the witnesses be supplied to the Land Council for the state. Put of this matter in the convention from 28th of July 2025. Yeah, IN number one so stay relation of find up again.
Tomorrow I will supply.
Welfare also officer, officer. On the learning council for the state shall obtain instruction about the criminal antecedent. Enough. Now about the produce the custody certificate. How will you jail conduct? Yes, next.
But if possible custodial certificate we obtain.
Yes. Yes.
Item 20.
20. Mr. Sahoo.
Yes, Lord.
What is the surrender certificate?
File your lords.
When filed?
My lord, on behalf of Mr. Gokulan, I am for the appellant in the first case, my lord. In the first case, I am for the appellant.
Wait. It is item number 20.
Yes,
My lord. I'm in subatom.
No, again, first item, the GCRLA number 92 of 2023.
Yes, sir, lord. On behalf of Mr. Gokulan, I am for the appellant, my lord.
कौन है ला?
But as per instructions, he has already surrendered, my lord, on 24/6/2025. On 24/6/2025.
Why are you not producing the surrender certificate?
Sir, we have not got it yet, sir.
You have not got it means you have to apply there and got it.
For the informant.
You are for the informant? No.
No, sir, appellant.
Appellant?
Yes.
Okay, connected appellant, yeah, appellant. All right, learning counsel for the appellant submits that he has received the instruction that after availing the interim bail period, the appellant has surrendered on Kebe surrender kala?
24/6/2025.
24/6/2025. However, is unable to produce the surrender certificate. That instruction be obtained from the Land Trial Court as to whether the appellant Niru alias Nirupama said after availing the interim bail period has surrendered in the trial court or not. For such purpose, file be placed with and register judicial. We do the ministry. Yes. Baki upon kota konala?
My lord, the plain surrender in time, your lords. I have filed the surrender certificate, your lords. And she has filed subsequent bail application, your lordship. Last occasion, your lordship directed to take instruction whether she has violated any government condition during bail, your lordship.
I pray sometime because this file is in.
Oh, yes, from the Land Council for the state seeks some more time to obtain instruction relating to the conduct of the petitioner while an interim bail. So put up this matter along with the other matter as you mentioned. So yes, next.
Lady, your lordship, more than 10 years.
Put it up top for you. Yeah.
Item 21.
There's Mr. Muya.
Origin corporations 12/9/2019. 12/9/2019.
Aguru bail reject is
No, ma'am.
Deposition copy the change.
Paper grade.
Paper way. Okay. Case कौन? P02.
From that, the appellant has Lavakar with the daughter of the deceased.
Eyewitness change.
PW4 is the better that he is the eyewitness.
PW4 is eyewitness.
Yes, ma'am.
Doctor?
No.
PM doctor gena nahi कौन?
13. 13. PW 13, but 1.
और आगे पढ़े हैं आई विटनेस कौन पोजीशन 4 नंबर सेक्टर पढ़न दो
I know the informant, namely Somnath, who is the uncle or kaka of my wife. I know the accused Danar Munda standing before me. I know the deceased persons, namely Ramay Munda and Champa Munda, who are my father-in-law and mother-in-law respectively. The occurrence took place about
2.5 years back at night on a Saturday in the house of the deceased persons. I was also present in the said house and I was sleeping. The accused had abducted my wife prior to the occurrence and he had threatened me over phone and told me to take back my wife or else he would kill me. And I refused to take back my wife. Thereafter, I gave the phone to my father-in-law, who also refused to take back his daughter, and the accused also threatened to kill him if he did not do so. Then both my father-in-law and mother-in-law refused to bring their daughter back to the house. On the previous day of occurrence, the accused drove away my wife from his house. On the night of occurrence, I was sleeping in the house with my son in a room and had locked the door from the inside. I heard noise and I woke up, and when I tried to open the door, I found that it was locked from outside. Then I opened the window of my room facing the veranda where my father-in-law and mother-in-law were sleeping. And I saw the accused there who was holding a hammer and assaulting my father-in-law and mother-in-law with it. Then I closed the window and raised the hula to call the nearby people. Hearing my shout, my villagers, Rabbi Munda, that is PW2, and Salai Munda, PW8, came running to the spot, and thereafter Govinda Munda also came. The accused fled away from the spot. Thereafter, the door, which was locked from outside, was opened, and I came out of the room and went to the spot and saw that both my father-in-law and mother-in-law had sustained severe head injury with heavy bleedings, and both were dead. During investigation of the case, my statement was recorded by the magistrate under section 164 of the CRPC, and after the same was read over and explained to me, I gave my ITI. Now, this statement was not recorded by the police. Police contradicts the statement of this present trial.
In what way is it? Why the contradiction part you put and prove to the IO? The main part is that he saw through the window that you were assaulting the father-in-law and mother. How many deceased are there?
Two.
So it's a case of double murder.
Yes, sir.
So that is a hammer was the weapon.
Yes.
And you assaulted both the deceased, and then you ran away. When the villagers came, and so the other persons who came to the spot hearing holla,
yes,
they must have seen also you.
Na PW2
जो रॉबी मुंडा सिलाई मुंडा रो स्टेटमेंट
Rabbi Munda became hostile.
अच्छा सिलाई
Salai Munda says that when he reached there was none except himself, the two dead bodies, and
then what about the presence of the appellant? Has he not stated?
No.
Okay. So how have you overcome the evidence of this witness PW4, which he has stated that
for the first time he has stated before this.
No, how can you say? You must have put the previous statement that about देखो तमें जो पुलिस पाखे जो देइथिलो जवानबंदी देइथिलो तादेरे ये जो तमें देखिलो खिड़ी पटे तम सासु ससुरों को ये हैमर रे मारला बोली एक कथा तमें कहि नथिलो और प्रथम थर पई एक कथा कहउछ एमति कि पचार जंदी आ प्रमाण करि जंदी
No.
How? The previous statement, in view of 145 of the Evidence Act, the previous statement should be confronted to the witness concerned to give an explanation, and it is also to be proved through the IO who has recorded the same. Then can only the contradiction will be taken into account. You have not put the previous statement, nor so that means that was there also in the 161 statement. Yanagono PW4 Matai Munda Marklo 161 statement. What time was that?
Any recovery? 27 is there?
Seven part is not.
Amar?
But PW10 is corroborating the statement of PW4. That is PW10. When I asked about the occurrence to Marathi Munda,
You the statement was 161, no, say witness wrong. Relevant part होची तापरे मु मोर 2.5 वर्षर पुओ को धरी घर भितर शोइली मोर सासु ससुर घर बारंडारे मशारी टाणी खटियारे शोइले राति प्राय 1-2 हब मु शोइला बेले गाई जगुआली नहीं गाई अंजुआली हेला मिति गं गं शब्द शुणिली तापरे दुलदाल शब्द शुणी मोर सासु ससुर को डाकिली से माने राहा न देवारु मु कबाट कोणरु देखिली दन्ना मुहा कोन बिना देखा गला accused तार पार्टी जो सुबिला जने कि 2 जन पिला दौड़ी पळेले शब्द सुबिला मते भारी भय लागला मु कोर्ट को चेष्टा कली का बाहर सिकली पड़थिला अच्छा मु भाबिली गनार मोर सासु ससुर को कौन कर देइछि मु जोरे पार्टी करी स्वांस आसो बाहर कबाट देइछि कि अच्छो दौड़ी करी आसो बोली पार्टी कली कबाट सहित बाल्टी बाड़े लोक जेमती शब्द पाइले आसीबे मु सेमती चिल्लौ थाई किछि समय पर लोक आसी पहुंचिले बाहर मते कौन देइछि कौन अछि बोले मते खोलिले नाही भीतर थाई मु सुनिली रवि बापा मुंडा कोता ये है बुढ़ा बुढ़ी को मार दी छंदी है सुन महात्मा छड़ी वाला पर लागला मते खोली दियो बोली कर दी कि संपर तो किया 350 तो
सब्सटेंशियली
भीतर दुलदाल शब्द शुणी खोलिले एवं देखिले दिना मुह देखिगला तापरे तार पार्टी मध्य सुनला जने कि ज्ञान पिला देरी पड़ेले सब भल लागला दिस इज देयर सो
He has seen him and the door was bolted from inside. That factor is also there and everything is there.
the door was bolted from
Outside.
बाहर लगा
object not to go out to call the person.
Testimony also is here. Testimony also is here.
so it is a double murder in council
Wait for
so thousands Arjun September after Puja homes yes
Item 22.
My lord, on behalf of my senior staff, kindly adjourn the.
next
Item 23.
23 Mr. Siddharth Gautam Das R. Behra SS Mahapadra Kena Dichara next
That was also rejected by all the cases has been
मैं ठीक है कि नहा दिया नहा next
Item 24.
The petitioner number 1 attained the age of 80 years old. Petitioner number 3 is the physical handicapped lady. And the
IA number 3128 of 2014 जोड़ा फाइल कर जंदी कहाँ पाई फाइल कर जंदी समस्त नो पाई कितने जन अप्लाइंट अच्छे दिया दे रहे
appellant 3. Petitioner number 1 is the old man.
79 years कौन ला इंस्ट्रक्शन कौन आई जी डाणम तुसे जो
Copy also not there.
कॉपी देना दी
Deposition
give the copy deposition copy ऐसे return reference 79 years जो आगु रिजेक्ट ही नहीं
ना
ताले डिपोजिशन कॉपी दे दन मेरिट रे सुनानी हो नहले बाकी एटा देखिवा
Who is handicapped out of 3?
Petition number 3 is the daughter of petition number 1. She is the physical handicap.
जोड़ा लेडी टे भी अच्छी आज Okay, the IN number 3128 of 2024, there is an application for bail. Land Council for the appellant submit that the appellant number 1 is at about 80 years. Judgment भी अपन 79 लिखा है
Still surviving.
Surviving and LCR is there, my lord.
He further submits that in the judgment also, the age of the appellant number 1 has been mentioned to be 79 years. A accused statement there. In the accused statement, also the age of the petitioner, appellant number 1 has been mentioned to be 79 years.
We have 79.
The learned counsel for the appellant submitted that the appellant number 1 is in judicial custody since the
Padala Pradhana. Since 26/9/2024.
26/9/24.
After conviction, but prior
prior to that.
Prior to that, he was in custody since 16 March 2011 to
just a minute.
14 March 2013. Yes, madam. All were well during trial.
Submit
and they have not misutilized the legal terms.
Submit that the appellant number 1 was taken into judicial custody on 16/3/2011. However, he was granted bail during trial and he has never misutilized the liberty.
On 14/3/2013.
On 14/3/2013. The charge sheet was submitted on 11/7/2011, wherein also the age of the appellant number 1 has been indicated to be 65 years. Considering the submission made by the learned counsel for the respective parties, since the age of the petitioner as on date is 80 years.
Petition number 1. Petition number 1.
Petition number 1 is at about 80 years, keeping in view the NALSA guidelines regarding release of the persons who are aged about 70 years on bail. We are inclined to release the appellant number 1, Khadar Pradhan, on bail. So far as the other appellants are concerned, learned counsel for the state shall produce the custody certificate and the interim application shall be taken into consideration on 28th of July 2025. Yeah.
Item 25.
You took adjournments to Mr.
My lord, I have obtained.
Only single appellant.
I state my lord directed me to obtain the criminal antecedent and custody certificate of the appellant, Gauti Krishna Swami, with the first right.
And
We'll go one by one. Criminal appeal number 25, 31 of 25.
31 of 25.
31 of 25 re, there is only one appellant. Let's see.
Only one.
Cigarette lane,
31.
31, 20, 25. 40. Krishna, Swami. देखिए कौन आसला भक्ति कृष्ण स्वाई is involved in এটা কোন এই যে এই কেস কো ছাড়ি কি না আর এ মিশাই কি
না না এই কেসটা ফার্স্ট কেসটা হচ্ছে এই কেস 283
283 তাছাড়া আর ওটা 251 আছে
মেলা one incident
গোটে কেস
মেলা
and
custody মেলা 10 months.
Yes, what is the case, Mr.
Murder. The case allowed that on 24/10/2020 allowed around 7:30 AM. That is the FIR story. That will come to in next submission. The appellant along with other accused persons reached the front of the shop room of the informant. Informant. PW6.
PW6.
Armed with weapons. At that time, PW3 and PW6 were present in the spot. Then thereafter I have prepared a note. Thereafter, the deceased arrived there in a motorcycle.
What is the name of the deceased? Nando
alias Govind Beda.
Yes.
And all the accused persons hurled bombs, as a result of which he was injured and fell down from the motorcycle, and everybody crossed his head with stone. And that's how he died. Well, there are as many as 6 eyewitnesses in this case. And we don't know 1 to 6. None of the eyewitnesses has stated that I was present in the spot of the assault.
Is it a correct one?
Yes, my lord. The petitioner was not present at the time of the incident.
What is the role of the petition?
There was a previous planning conspiracy that is on 2 days before. That is on 21/10/2020.
Just a minute. 2 days before the occurrence.
My lord.
What is that date you said?
21/10/2020. And the occurrence of on 24/10/2020. 24/10/2020. 21 October there was a
planning जो कुछ in the car
what is PW4 and PW5.
PW4 and PW5.
I will come to that. That so far as the appellant is concerned, his case has been discussed in paragraph 16 and 17. May I place it?
Mr. Mahati, he has accepted that eyewitnesses are not in.
Let's come to 4 and 5.
Then we'll
conspiracy part is concerned.
We'll go to that.
That has been discussed in paragraph 16.
No, unless we see the evidence, we cannot.
17. I am coming, Miller.
Yeah.
But your lordship see whether he has believed PW4 and 5 or he has gone with the other evidence. That is why I want to place it. I will place it, Lord. I am not shying away from it. I may be permitted to bring to your lordship's kind notice paragraph 16, Miller, at page 69 of the appeal. Turning page 69.
No, we are told that when the judges want something, that should be placed fast. That was, we are told.
That's all right, Miller. I thought it will be better, Miller. I am placing.
We want to see that.
All right. All right. Then no problem, Miller. Since I thought,
No, we'll go to that. We had not.
Lordship.
Yes, please come.
Sorry.
Para 2.
Lord,
PW4.
এটা হলো PW4
21 তারিখ ঘটনা বিষয়ে যাহা কইছে
Paragraph 3 on 21/10/2020 at about 10 p.m. Lordship will kindly take the time. I'll come to the time factor later. While I, along with Bharat Behra, were going in front of Ram Mandir of our village, on the way I found all the accused persons were gathered near Ramlila Mandap, and there was a meeting between them under the leadership of accused Gatikishta Swai, and I heard from them that they have planned to attack on the house of informant Sunit Khatwal.
This man is Gatikishta.
Then, my lord, your mercy will come to paragraph 4.
Yes. That relates to that occurrence. Occurrence you have not been named.
In the occurrence, my lord, the accused person, those who are asserting.
Mr. Bhanti, we just want to know that you have just said that the eyewitnesses have not implicated you in that occurrence part.
Yes.
Anything is there in that occurrence part, or it is only that criminal?
No. The furthermore is that is why I was placing paragraph 4. He has also stated ୟାକୁ ମାରିକି ସଫା କରିଦିଅ, ଆମ ନେତା ଗତିକୃଷ୍ଣ ଅଛନ୍ତି, ସବୁ ଖର୍ଚ୍ଚା ବହନ କରିବେ। ଏଇଟା
ସବୁ ଖର୍ଚ୍ଚ ବହନ କରିବେ।
paragraph 4 ରେ ଅଛି ସେଟା। ସେଟା ହଉଛି 1 2 3 4 15th line from the of the paragraph 4.
Now we got it, that we have underlined it. ୟାକୁ ମାରିକି ସଫା କରିଦିଅ, ଆମ ନେତା ଗତିକୃଷ୍ଣ କହିଛନ୍ତି ସବୁ ଖର୍ଚ୍ଚ ବହନ କରିବେ।
ତାପରେ ସେଠୁ the next witness is PW5.
My brother was asking that ସେ ମଧ୍ୟ କହିଥିବ ଯେ ଯଦି ବି କନଭିକ୍ସନ ହୁଏ ଅପିଲ ଖର୍ଚ୍ଚ ମଧ୍ୟ ବହନ କରିବେ।
And he's honestly doing that. It appears. Para 2. About 2 years back, one day.
About 2 years back, one day, that is on 21st during the month of Dasara, at about 6:30 p.m. Has your lordship got it?
Yes.
10, there he said 10. He says 6:30.
Yes, that's the timing. While I was going to the house of informant Sunita Khatwal, on the way I found all the accused persons were sitting in Ramnala Goda near the house of Gatikishta Swami. The place also undergoes a change.
Different place.
The time undergoes a change, place undergoes a change. And they were organizing a meeting. This I told my nephew Nanda Govinda Behera about the same.
But he has also not heard what is the discussion.
Yes. No, discussion part ta kichhi kahini.
Whereas PW4 says that I heard it. Discussing. That's the difference.
They were going together.
PW4, PW5 ର contradiction ଟା ମୁଁ ଖାଲି ଦେଖୁଛି।
PW4 ଆଉ PW5 ଦି ଜଣ ଯାକ ସାଙ୍ଗ ହେଇ ଯାଉଥିଲେ। ତ ସାଙ୍ଗ ହେଇ ଯାଉଥିଲା, ଜଣେ କହୁଛି 10ଟା ବେଳେ, ରାତି 10ଟା ବେଳେ, ଆଉ ଜଣେ କହୁଛି 6ଟା ବେଳେ।
Place is different.
Place different. ଇଏ 4 ନମ୍ବର ସାକି କହୁଛି
PW5 ଟା ହଉଛି ତା uncle of the deceased।
ଏକାଠି ତ ଯାଉଥିଲେ ସେ କହୁଛି ଆଉ।
Then PW6. Nice. PW6 is not telling anything comfortable into paragraph 230.
But it doesn't say anything about
The
21st.
time
21st, yes.
এটা 24 হ্যাঁ এটা সেটাতে ଅଛି ପିରିୟଡ଼ ଉପରେ ଏଇଥିରେ ପ୍ଲେସ୍ କରିଥିଲେ ଏଟା and at that time accused Padya Swami was saying ଆମ ଦାଦା ଗତିକୃଷ୍ଣ କହିଛନ୍ତି ୟାକୁ ମାରିକି ଶେଷ କରିଦିଅ ସେ ସବୁ ଖର୍ଚ୍ଚା ବହନ କରିବେ ସେଟାରେ ନଥିଲା ଯେ ମାରିକି ଶେଷ କରିଦିଅ ୱାର୍ଡଟା ନଥିଲା ଏଠାରେ ଆଡ୍ ହେଲା ମାରିକି ଶେଷ କରିଦିଅ ତାପରେ ସେଠୁ ଆଉ ଗୋଟେ ୱିଟନେସ୍ ଅଛନ୍ତି ଏବେ ତ ପିରିୟଡ଼ 4, 5, 6 ତ ଆଉ
4, 5.
5, 6 ବି ନାହିଁ କିଛି
ଆଉ
ଗୋଟେ PW1
ଏଇ 4 ଜଣ ଆଇ ୱିଟନେସ୍ ପରା 1, 3, 5, 6 ଅନ୍ୟମାନେ କିଛି କହିନାହାନ୍ତି ଏଇ ଯୋଉ ଲାଇନ ଟା ଯୋଉ କହୁଛନ୍ତି ଯେ ମାରିକି ସଫା କରିଦିଅ ଯେ କହିଛନ୍ତି ବୁଝିବେ ବୋଲି ସେଇଟା ଅଲ୍ ଦି ଆଇ ୱିଟନେସେସ୍ ହାଭ୍ ଅଲସୋ ସେଡ୍
ନାଇଁ ଆଉ କେହି କହିନି
ଓକେ ନା ନେଇ ନାଇଁ ଏଠି କହିଛନ୍ତି ୱାନ୍ ବି କହିଛି
one ହଉଛି 4 ର ପୁଅ
we just want to know that out of the 6 eyewitnesses, Mr. Mahanti, 1, 2, 3, 4, 5, 6, you have stated that ये जो occurrence बेड़े माने पहिले ये मारी देखो
1, 4, 5
Except 3 others, all. 6, except 3.
1, 4 ଆଉ ଏଟା କେତେ
1, 4, 5
ହଁ ତାହେଲେ
1 କହିଛି
1, 2 ବି କହିଛି 1, 2, 4, 5
ଠିକ ଅଛି 2 ବି ପଢିଆ
6 also
3 କହିନି
ସମସ୍ତେ କଣ କରୁଛନ୍ତି ସମସ୍ତଙ୍କର ଷ୍ଟେଟମେଣ୍ଟ ୱିଦିନ୍ କୋର୍ଟସ୍ ଅଛି
little variations
ନାଟା ଆସୁଛି ଗତି ପାଇଁ କହୁଛନ୍ତି
ଆଜ୍ଞା ତାପରେ ଟାଇମିଂ ଟା 3 ଜଣଙ୍କର ଅଲଗା ଅଲଗା ଟାଇମିଂ ଅଛି ସେ ଯୋଉଟା ଗଡାରେ କନସ୍ପିରେସି କଥାଟା ଦେଖିଏ ସେଟା କହୁଛି ଟାଇମିଂଟା କୋଉଠି ଦେଖିଥିଲି
4 and 5
4, 5 ଆଉ ଗୋଟେ ଅଛି ଟାଇମିଂଟା 3 ଜଣ ରହିଛନ୍ତି
4 କହୁଛି ରାତି 10ଟା ଇଏ କହୁଛି 6:30
ଆଉ ଗୋଟେ ଅଛି
now let us see how the trial court deals with this how trial court deals with that let us see
সেটা কিছু নাই trial court deals with it in paragraph 16 and 17 may not take your
now you can come
let us
page 69 on the running page 69 of the appeal internal page 32 of the judgment PW14 is the eye owner.
yes 60
Now I will place the eye evidence, but let me first place this, or I will place the eye evidence first and then come to this.
You can come to the से जो ए पोर्शन रो किछि मैटेरियल डिस्क्रिपेंसी अछि ये जो लाइन टा से माने ऑर्डर करले जे सळा को मार दियो से जो ये कहिसंती बुझिबे एई एमाने समस्ते 161 रे कंसिस्टेंट अछि ना नाही किछि वेरिएशन आनी चंती आईओ जरिया रे
नहीं से कथाटा
नहीं तो बस पळे आसु आपण जजमेंट को पळे आसु देखियो के हम डील कर जंदी जो क्रिमिनल कॉन्स्पिरेसी टा और जो ए दीटा पार्ट लेकिन तो कन्विक्शन है जी
35 is very important. Exhibit 35. That's an entry. Prior to occurrence given by one of the ASI police that I have
given. Submission टा एने हेजिया दरकार बिफोर कमी बचना ना
just please
PW14
सब कहीं होते सब को
the appellant's conviction this appellant means this Gati Krishna his conviction is based on the statement of PW 4 and 5.
And a station diary which has been entered into earlier to the murder.
ସେଥିରେ କ'ଣ ଅଛି?
ସେଇଟା ପଢୁଛି, that is very interesting.
କୋଉଠି ଆସନ୍ତୁ?
Paragraph 16.
Paragraph 16 of the judgment.
Judgment below, internal page 32, running page 69 of the criminal opinion. It is furthermore stated by PW 14 in paragraph 56 of his cross-examination that he came to know that police protection was provided to Sunita Khatua, informant and wife of the deceased, and her family member on the basis of a station diary by GD dated 12/10/2020 of Suvarnapur Beat House under Banki PS, died exhibit 35. No.
The conspiracy is dealt with page 70 to explain such aspect.
That date will be 21/10/2013 instead of 12/10/2000.
You read the next paragraph. To explain such aspect, learned additional PP has forcefully argued that stating that prior to the murder of the deceased, there was a conspiracy.
Next page.
This is the conspiracy. To justify such aspect,
he relied upon exhibit P35.
Yes.
The station diary white 22/12 হয়েছে, এটা 22/10 now.
ঠিক আছে।
Of Suvarnapur Beat House under Banki PS and the statement of PW 14, one of the investigating of this case, who had categorically stated that on verification of the extract, your lordship will kindly note, extract of SD GD number 12 dated 22, he came to know that this was regarding conspiracy meeting held by accused person under the leadership of accused Gati Krishna Swai on 21/10/2020 at 9 p.m. 7:30-10, and here it becomes 9 p.m. in Ramlila House, Gholapur, in order to teach a lesson to Sunita Khatua and her family, and the contention of the accused person was that as to why she lodged a FIR against them. All the accused persons had attended the said meeting, and in that meeting, accused Gati Krishna Swami assured the accused person to bear all the expenses and provide protection to all accused persons. So it became clear that prior to such alleged murder of deceased, a meeting was convened in which plan was hatched, and accused Gati Krishna was the director of that meeting. Your lordship will kindly see. So scenario of the instant case clearly entails that the 4 stages of commission of offense, intention, preparation, attempt, and commission are concretely established without any doubt. With regard to abatement of the offense by accused Gati Krishna Swami, the evidence of PW 14 and exhibit 35 are sufficient. But this is what is directly, so far as the meeting of others is concerned, 16, so far as me, 17. According to the Indian Penal Code, abatement of the act of encouraging or helping someone to commit a crime occurs in 3 ways: by instigation, conspiracy, and aid. Accused Gati Krishna Swami was involved with the intention and knowledge for execution of the crime, which was finally committed. If that it is so, the abater receives the same punishment as the principal offender. Bereft of such involvement of accused Gati Krishna Swami with the alleged crime becomes more concrete from the statement of other witness. On this score, PW1 in para 2 of his examination chief has stated that deceased had a shop, in one occasion had been to the house of the deceased and threatened the Bhauja of PW1 to kill the deceased, as the deceased was reluctant to act as per the instruction of Gati Krishna Swami, who was a politician of the village. PW1 has also further stated in paragraph 3 of his examination in chief that while the accused persons asserted the deceased
being fortified with lethal weapons by them, all the accused person uttered as such, ଶଳାକୁ ମାରିଦିଅ ଗତି ଭାଇ ଅଛନ୍ତି ଆମର କିଏ କିଛି କରିପାରିଲେନି. This statement is different from the PW 456. Apart from this, further statement of PW1 is that during the time of assault and deceit by the accused person, accused Padhyasai was shouting at the spot, uttering as Gati Krishna କଥାରେ ଯିଏ ନ ଯିବ ତାକୁ ସେ ଯେମିତି କହିଥିଲା ଆମେ ସେମିତି କଲୁ ତାକୁ ଜୀବନରୁ ମାରି ସଫା କରିଦେଲୁ. Likewise, PW2 in paragraph 3 of his examination has stated that by the time when assault was committed on the deceased, all the accused persons were shouting, uttering as ଶଳାକୁ ଜୀବନରୁ ମାରିଦିଅ ଗତି ସ୍ୱାଇଁ କହିଛି ମୁଁ ସବୁ ଖର୍ଚ୍ଚ ବୁଝିବି. The same statement is also given by P in paragraph 3 of the that during the time of assault, the accused person shouting, uttering ଶଳାକୁ ଜୀବନରୁ ମାରିଦିଅ ଗତି ସ୍ୱାଇଁ କହିଛି ମୁଁ ସବୁ କଥା ବୁଝିବି. Likewise, PW4 in paragraph 4 of his exemption has stated that by when the accused persons were acting the deceased by them, they were shouting, uttering as ଆକୁ ମାରିକି ସଫା କରିଦିଅ ଆମ ନେତା ଗତି କୃଷ୍ଣ କହିଛନ୍ତି ସବୁ ଖର୍ଚ୍ଚ ବହନ କରିବେ. PW6 has stated in paragraph 2 of his exemption in chief that while the accused persons were assaulting the deceased, by then accused Padhyasai was shouting, uttering ଆମ ଦାଦା ଗତି କୃଷ୍ଣ ସ୍ୱାଇଁ କହିଛନ୍ତି. Again and again see the same statement. Accused person uttered the name of Gati Krishna by the time when they assaulted the. Of course, there cannot be smoke without a fire, as Gati Krishna Swami had instigated the accused person by hatching a conspiracy to commit murder of the deceased, for which out of extemper the accused person uttered his name by the time of committing the crime. Accused Gati Krishna Swami is the abettor and the mastermind of the crime, having concealed himself behind the screen. ନାଇଁ ସେଇଟା ଆଉ ଆରଟା ସେ PW15 that station right exit 35 ବିଷୟରେ ଟିକେ PW14 ର statement. Has your lordship got? Yes. PW paragraph 16, PW14.
Who has proved exhibit 35?
Who has proved exhibit 35, that extract of the station diary. On 17/2/2021, I also collected extract of station diary by GD number 12 dated of Suvarnapur Beat House and Banki PS, and on verification of the extract of the diary, I came to know that this is regarding conspiracy meeting held by the accused person under the leadership of accused Gati Krishna Swami on 21/10/2020 at 9 p.m. in Ramlila House, Golapur, in order to teach a lesson to Sunita Khatua and her family, being aggrieved as to why he has lodged a FIR against them. And in that meeting, accused person such and such attended the conspiracy meeting. I assured the accused person to bear all expense, give protection. This is the attested true copy. This is not even the extract. Has your lordship got it? This is the attested true copy of the extract of Suvarnapur Beat House entry number 7, now marked exhibit 55, with objection by defense. Then we got the exhibit 35. My submission for your lordship is not a primary evidence. Because that station diary register was available, it could have been produced. He takes an extract, he says that I have taken an extract of this, and then marks as exhibit the attested copy of the extract.
Who has attested?
He himself?
He himself?
Self-attested.
Yes. He was voting.
Self-attested. That's the reason there was an objection.
No?
The
That
defense is
our
objected.
objection to- Defense objected to the.
Yes, we
That
object.
is why we objected.
That's the reason. Yes.
But that has not been dealt with.
That has not been dealt with anywhere in the judgment. What is the evidentiary value of exhibit 35?
If the minus 35 is, if not consider also, the what is your answer to the other evidences?
Other evidence, Lord, your Lordship, I have shown your Lordship how it differs from person to person. And other evidence, they say that Gautya, your Lordship sees the story. If 21st meeting is believed, then it is to kill Sunita Khotwa.
Sunita.
Family member.
To
teach
to teach a lesson to not to kill. Nobody is studying to teach a lesson because they have lost an FIR against the accused persons, not against Gautam Sahi. And Gautam Sahi says that I will teach them a lesson, I will take care of that is the meeting. About the statement of the meeting by all the accused persons. Then, if the second question is about the difference.
The PW4 says that they are planning to attack the house of informant. Fatwa.
Why should they go to the shop?
Attack the house, not to teach the lesson. Attack the house. That was the version of PW4. What PW5 says.
PW4 is the uncle of the deceased.
PW4 is the uncle of the deceased.
Who is the
PW5?
He is the witness who is for conspiracy. He was examined. He says that they were discussing to take to attack the house of the deceased.
Yes. No, that's right.
So this is the evidence available.
My lord, my learned senior placed that there was time gap between the statement of PW4 and PW5. I am placing
we are not on that. Have you seen any conspiracy to kill somebody is made in open place in a Ramgala Maidan and that to hearing of others, or some conspiracy is to be held in a secret place so that others will not hear it? How far it is believable that
the question of my lord appreciation, my lord.
They will discuss
whether it can be possible or not possible.
No,
but
at about 10 o'clock in the night, you say meeting was held, and prior these accused persons were present, and they will be attracted.
10 o'clock, 9 o'clock, one can believe. One witness says 6:30.
No, my lord.
That
I am trying to extend, my lord. At 6:30, he is not saying that they were planning to, they are conspiring to kill, my lord. At 6:30, he is saying that they were congregated, not planning.
The planning went on till 6:30 to 10 o'clock.
Yes, my lord.
They went together.
No, PW5 is not saying that they went to whether PW5, my lord, I am placing, my lord.
PW4 and 5, according to PW5, I was with PW4.
Yes, my lord. That is at 10 p.m. That is at 10 p.m. But PW5 saying that on 21st, during month of Dasara at about 6:30 p.m., while I was going to the house of informant Sunita, on the way, I found all the accused persons were sitting on Ramlila Ghara, near the house Ramlila Ghara.
They were organized.
Only PW5 is saying that, while he is also not saying that he was going with PW4. He is saying that while I was going to Sunita, he found that all the accused persons were congregated at that spot, my lord. And PW4 is saying that when he along with PW5 were coming at 10 p.m., they had. That part PW5 is not saying.
So which one is correct? If you say
both are correct, my lord.
Well, how can you both?
My lord, because PW4 stated that he along with PW5, they were, while they were passing that road, they
at what time? At what time?
10 p.m.
Aji stated this. PW5 has stated that I went with PW4 at 10 o'clock.
Why that part of the story is missing in PW5?
PW5.
Why is he not saying that 10 o'clock? While I was returning,
Perhaps he has forgotten that part.
But that apart, my lord.
No, I thought that
Prior to that,
yeah, that perhaps if the discussion was going on and a mic was there and they may.
We're declaring that we are going
that
to
apart,
attack another country.
prior to that also,
For
there was
6:30 to 10
apprehension
o'clock
of,
conspiracy.
danger. There was apprehension of danger. In that respect, one stationary entry was made, my lord.
No, conspiracy, we are not on the persons who are assaulting the deceased. We are that you are, so far as this meeting, conspiracy meeting is concerned, you are adducing two witnesses, 4 and 5.
My lord.
But there are
And
discrepancies.
exhibit 35, my lord.
Exhibit 35, but it was lost on the next day. That is on.
ঘটনা ঘটবার ଗୋଟେ দিন ପୂର୍ବରୁ।
17, that is on 17.
No, that exhibit is 22nd. এই ঘটনাটা এই মিটিংটা নাই, মিটিংটা ହେଇଛି 21 ତାରିଖରେ। ঘটনা ହଉଛି 22 ରେ ଇଏ ଦିଆ ହେଇଛି
ଷ୍ଟେସନାରୀ 22 ରେ।
You come to that stationary entry ଯୋଉଟା
Exhibit 35.
Exhibit 35. Come to that.
Extract of that.
Have you seen it, the extract?
My lord.
You read it out, read that. What is written there?
12. SD number 12.
File 264 पृष्ठा. Total page होची 1939 and the relevant page is 264. Got it, Mr. Please press it. पढ़ो. अपन पढ़ो कौन लिखा है? नहीं
I along with
Mr. Madhu, just check it. Yeah.
I along with the C509 RCH Parida returned to BH and told DC from Constable 161 AK
took diary charge. Told like
with no accused
in beat house.
In beat house. I may note here that while I, along with staff performing patrolling duty at Gopalpur, received information from a reliable source that under the leadership of Gati Swai, alias Gati Krishna Swai, a closed door meeting was held in Ramlila House, which is located in front of the house of Gati Swai on 21/10/2020 at 9 p.m. Antisocial Musei Behera, Posa Akwa,
All the names,
all the accused persons. Also
And others also
attended the meeting. As Sunita Khatua, wife of so the deceased, was lodged FIR against them, they decided to teach a lesson Sunita Khatua as she has lodged FIR against them. Gati Swai assured all the members to provide necessary protection as well as bear all the expenses if required in future. Hence, all the members vehemently assured Gati Krishna Swai, they also utilized their muscle power as front shoulder. Hence, I brought the fact to the notice of my IIC, who directed me to perform evening patrolling and night patrolling duty regularly. Noted the fact in SD for future reference, my lord.
It is a closed door
My lord.
conspiracy.
This shows that the present petitioner has active role behind this crime, my lord. There was a stationary entry and witness have also stating that there was previous conspiracy and the witness, those who are eyewitness to the occurrence, they are also uttering the name of the present appellant, my lord.
Okay. Yes, Mr. Raghav, what do you say?
Prior to the incident, meaning prior to the conspiracy, my lord, we told
40, my lord. I know. In paragraph 13, stated that on 8/1/2021, I verified criminal ancient of accused persons, namely Padiyad is a Pradeep Kumar Swai and Gautik Swai, and I found that accused Padiyad as Pradeep Swai is also involved in Banki PS case number 226, dated 23/8/2020, and Banki PS case number 251/20. Accused Gautik Swai also involved in the Banki case.
The instruction आनी bra, eta आनी
251, my lord. That is the root of my lord. Motive is comes from that place, my lord. Sunita, my lord, law the information is Gautik Krishna and other persons, my lord. Prior to the 354 offense, 294, 147, 148, 149, and section 3 of the exclusive substance are registered, my lord. And always, my lord, threatening you, they pressurize.
What happened to that case?
That case, my lord, but though we have, my lord, whether that has been completed or not, I have no instruction, my lord. But in fact,
you are appealing for the informant and you have got no instruction given.
With regards to
charge sheet has been.
What is the status of that case? Charge sheet submitted.
Due to that case, my lord, thereafter conspiracy, my lord, under the leadership of Gautik Krishna. Then, my lord, the stationary laws by the, my lord, the none other than the police officer himself, my lord. Why should, my lord, the discipline the police public servant, my lord?
No, they have the police officer heard from reliable sources, and accordingly, this extract was exhibited there.
And provided police protection. For the disease, my lord, apprehending danger to the life of the deceased and the family members. And they are
very serious case. Writing 354, 506. And the other case, that case is also not a very serious case. And the offense is just see 323, 354, 294.
That case is
and
serious.
Section 3 of the Exclusive Substance Act, my lord. Each and every case on 3 of the Exclusive Substance. Here in the case, my lord, there were 3 bombs, my lord. They have always utilized bombs, my lord. And Golapur area, my lord, there is, my lord, Gautik Krishna is the leader of the ring leader, tail leader, my lord. He committed one of, even if, my lord, after the case, my lord, judgment, my lord, one of the people one's family members' wife threatened and assaulted by Mr. Panic, my lord. That is another case arrested, my lord. Petitions are custodied, my lord. The case story shows that, my lord, Amopo Kesavara, Golapur murder case, Saki Hoitwaru, Mona Lagoraki, Assignment, every Hotna Santi. Hatare, Manas, the Dotha, Poturi, Tangia, Fasa, Tanga, Hatari, Amoko Hotat, after the judgment, my lord. They are henchmen, my lord. One of the assaulted the family members of one of the.
In that FIR, the name of these people are taken?
No.
Anybody's name?
खाली कौन सी घोड़ापुर केस this case माने घोड़ापुर केस में साक्षी थे और ये कांडा पटिशन हटाता
in this case
माने
अच्छा
ये केस पे साक्षी दिले केस of Peter 1
the
case is going on that area my lord
this is how we
घोड़ापुर area my lord one after another there is crime my lord earlier also there is cases my lord
Dholpur case means no this is the Banki case na
घोड़ापुर केस ये घोड़ापुर गाना बाकी केस है घोड़ापुर खाना घोड़ापुर area ना घोड़ापुर
village name Golapur.
Who all are the accused there in that case after judgment?
After judgment, the henchmen of this accused persons.
Has anything has come there?
Sini Behera, Prema, Brahma, younger son of Sini Behera. Specific answer that
this appellant in the note they have submitted that he was arrested on 27/10/2020 and he was directed to be released on bail on 23/12/2020 and this judgment was pronounced when?
On 8/11/24.
8/11/24. So for about 4 years after being released on bail, this man was on bail. Any report was lodged about his misutilization of liberty by the. He has not. Nothing has been found.
That instruction.
No, in fact, the informant approached the Supreme Court for cancellation of the bail, but that ended with a direction that you complete the trial.
No. We just wanted to know this about this aspect. So anything adverse reported?
Nothing.
That instruction I have not talked to my lord. I got it.
You can take up day after tomorrow. You get the instruction. Have you received the note copy?
This note.
अरे नोट मैं आपको तो नोट का पते दियो तो you come to this page number 7 of the note.
What the copy thila
Note दिया
अरे
मुंह बाहर कर
इधर वो दे दियो
You see, come to the last page. There, what he has been written down that Gotti Krishna was arrested on 27/10/2020 and he was released on bail on 23/12/2020.
That is true.
Now, the judgment is pronounced on 8/11/24. So, almost prior to again being taken into custody, he was on bail for 4 years. Pakhapagi. So, we just want to know that during that period, whether there is any allegation of misutilization of
I have
liberty.
to upon that.
कारण आपनकर केस किसी लॉज हेनी जा जो गोटे केस लॉज हेची ए केसटा जदी 283 नंबर हुए जो आरो केसटा होची ता पूर्वरु केस हेची 251 टा
251
राइट सो 251 केसटा प्रथमे तापरे मर्डर केसटा आसिला तापरे से ए केसटा आसीची सेई कनेक्शन रे ये अरेस्ट हला 27/10 रे आ बेल रिलीज हेची 23/12 रे तापरे 4 वर्ष परे पाखापाखि जजमेंट हेची तार भी स्टेटस टा नहीं आसुनु मिस्टर महांती सेज दैट इट वाज जस्ट चार्ज शीट वाज सबमिटेड हाउ किछि प्रोग्रेस करनी तार हां
And Mr. Raghunath, whatever you are saying, that also.
One paragraph from a judgment note reported in 2016 Supreme Court cases 483. Here is the exit 35.
Which paragraph, Mr.
Paragraph 15.
15. Yes.
The preconditions for needing secondary evidence are that such original documents would not be produced by the party relying upon such documents in spite of best efforts, unable to produce the same which is beyond their control. The party sought to produce secondary evidence must establish for the non-production of primary evidence. Unless it is established that the original document is lost or destroyed or is being deliberately withheld by the party in respect of that document sought to be used, secondary evidence in respect of the document cannot be accepted.
Section 65.
It also relating to that exhibit 35. এটা অর্ডারটা লিখুন তো CRLA number 31 of 2015 are Mr. Ashok Mahanti, Land Senior Advocate, and Mr. Harmon Dhar, Land Counsel for the appellant Gotti Krishna Swine. Stop. The Land Counsel for the state, as for the order dated such and such for the has produced the written instruction received from the IAC Banki Police Station, which is dated 13/7/2025, which indicates that apart from this case, the petitioner is also involved in another case, that is Banki PS case number 251 of 2020. And he has also produced the custody certificate of the petitioner, which are taken on record. When we made a query to Mr. Mahanti about the status of the other case, that is Banki PS case number 251 of 2020, is submitted that he has instruction that in the said case, charge sheet has already been submitted. Stop. Mr. Mahanti filed a short note of submission on behalf of the petitioner, wherein it is stated that the petitioner was arrested on 27/10/2010 and he was released on bail on 23/12/2020, and he has never violated the conditions of the bail order. Mr. Nayak, an additional government advocate, who has received the copy of the short note from Mr. Mahanti, seeks some time to obtain instruction on this aspect. Put up this matter on 16th of July 2025 with the connected matters. Acha, Mr. Mahanti placed a citation of the Honorable Supreme Court in case of Rakesh Mahindra versus Anita Bari and others, reported in 2016 Supreme Court cases 483, relating to substantiate his submission that Exhibit 35, the extract of the station diary entry or general diary entry, সেটা কোন সেটা? Station diary entry dated টা কেটে 22/10/2020 is not admissible. The decision is also taken on the form.
My Lord, Criminal Appeal 50 of 2025, accused number 5. Same accused file another appeal, that is Criminal Appeal number 430 of 2025.
Separate file করছি?
Separate out file করছি 430 টা।
So either you are to deal with his name or this file, this appeal would go. Mr. Pandan.
Let him be asked to submit. Let him be queried as to whether he wants.
Then ଆପଣ କହିବେ ନା?
ମୁଁ ପଚାରିବି।
ହଁ, appellant number ସେ କହୁଛନ୍ତି CRLN number 50 of 2025 ରେ appellant number 5 ହଉଛି ସୁସା alias Sushant Kumar Akua, who is the son of Vrindavan Akua, and he is the appellant in CRLN number 430 of so that is how either that name is to be deleted from CRLN number 50 of 2025 or this appeal is to be not placed. You just take it on prior. সেটা মনে পকাই দেবে, then rest of the matter on.
In the other matter, in the next matter, I'm appearing to the
কোটা কইলে? 23 or
26, Criminal Appeal 32 of 2020.
Just a minute. Item number 26, Mr. Devasis Panda and his associates filing wakalat nama.
Memo of appearance.
Memo of appearance, which is taken on record. The name of the Land Council be reflected in the cause list henceforth. Upon कौन पूछले?
27 টা মেল interim bill আছে, was the date?
কেবে?
আচ্ছা, এবং কিষ্ট থেকে আছে।
একো item টা কোন?
Item 27
of দুইটা item আছে।
First item CRL 68 of
তাদের এই যে IN number 1855 of 25
1855
সেটা ভার কোন?
27
কোন এরা আসিল?
mother died.
দেখুন IN number 1855 of 25, there is an application for interim bail filed by কাহার মদর ড্রয়িং?
Appellant number 1.
আর সমস্ত ভাই ফাইল করে দিলে কিন্তু
appellant number 1 1855
for appellant number 1 का नाम कौन? Tanya C. Rao for grant of interim bail on the ground that his mother has expired on 7/7/2025. The Land Council upon aguru kuaitla matter instruction no
last date.
The Land Council for the state was asked to obtain instruction in the matter. Today the Land Council for the state has produced the written instruction received from IAC Bodabajar Police Station that the mother of the petitioner passed away on 7/7/2025. The written instruction is taken on record, considering the submission made by the Land Council for the respective parties, the governments taken thereon, and therein, and the written instruction received. We are inclined to release the appellant number 1, Swan bail. The interim bail period will start on 15th of July 2025, and the appellant number 1 shall surrender before the Land Trial Court on 1st of August 2025, matter to be listed on 11th of August 2025. Land Council for the appellants has produced the surrender certificate. है ना? Very secure करते हैं.
in course of